Good morning. Good morning. Oh, shoot. I was trying to see something. Good morning. So we know today is day 6. Day 6 of Tennessee versus Blaise Taylor. But today is day 1 in Blaise Taylor's case in chief. Now, while we know that Blaise Taylor is not obligated to say a thing or do a thing and can just sit there cloaked in the presumption of innocence, looks like they have a maximum of 10 possible witnesses. Hold on, y'all. Let me switch this over because apparently the video didn't upload. Yes, I'm live and I'm switching y'all off my glasses. Because it's only from this one. Because apparently my video ain't uploading because y'all's asses is in the way. Whoopsies. How was movie night? Was hilarious. Movie night was hilarious. We had Dallas chose Toy Story 4 and 3 since 5 was still in the movies. I'm like, you just went and saw 5. But somebody else made a debut. Let me see if I got the video still. Y'all see Mister? Did y'all see him? So he has 2 teeth at the bottom. So nephew came over. We bought baby nephew. So everybody was outside listening to Dallas and Denver, and all my neighbors got to hear them belting out, "You got a friend in me."
A couple of grounds, one being that no trier of fact would be able to hear or at least deliberate on the evidence that's been placed before this jury for the following reasons. One, in regards to the 225-23 blood that was considered by the medical examiner in determining the cause of death. In that regard, the witness testified that, and when I'm speaking of the witness, I'm speaking of Dr. Bethune. Dr. Bethune testified that there was no way that she, well, I shouldn't say that she considered and had to rely on the summaries of the individuals who performed the test for litigation package.
What are you arguing about? Chain of custody?
No, Your Honor, the state, Smithy, Arizona, in regards, there was a surrogate witness that was placed on the stand after her testimony. It was developed that she had to rely on the summaries of the individuals that actually performed the testing on that vial of blood for 225-23 and work order number 231-26889. That is the very vial of blood that the medical examiner relied on in determining the cause of death for Ms. Benning. Given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violating the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed in work toxicology report number 231-26889, there is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Benning. In addition to that, there has not been one witness that has come and tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort during the
Does there have to be?
We believe that there has to be a causal connection between Mr. Taylor and the cocaine in order to determine that
With
he.
just the proof based on who was in the apartment for the 3 minutes between the 911 call and Ms. Benning's call, wasn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that
There's
3
plenty of
minutes of time.
testimony that it's been very quick.
However, they did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any
Be
evidence to
somebody in
suggest
the
that.
apartment, we, Danny, I mean, that's a jury question.
It is the defense position that no causal connection has been made between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for judgment of acquittal.
Okay. All right, does the state care to be heard?
What was that noise?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis.
No, she didn't.
Substitute witness.
Start with something else.
Reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, the state admits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that she just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Ms. Benning's case. There is I would say proof beyond an absolute certainty that Mr. Taylor was the only one with Ms. Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay. All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimonial Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Mithun talked about each batch, but said that didn't affect her reliability, her testing, she looked at a number of them. She was asked specifically how many, but, and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there, so that's not my role to judge credibility. If they believe Miss Jackson's statements, then the cited utterance from Miss Benning tells us who it was. So I'll go through the motion for judgment of acquittal. And who is the defense first witness? James Smith, is he here?
He is here, I understand. Really briefly, Your Honor, I think we need to test our.
I think that was the best.
Oh, I thought that had already been done. People were here.
I love the way the judge said that. I know he can get a little spicy. I know that he can say things, or his delivery can be a bit brash, but I love the way that the judge just said that, because that's exactly what this boils down to. I believe so. He just said detective something. But he didn't say, oh, it's the definite, he has connection or cause to the drugs. He has connection or cause to this, or it's probably in his wheelhouse to do something like this because of this. He said, there's no doubt that he was the only one there. And he even said during those 3 minutes between Jade's call and the 911 call, he's not saying the whole entire time. During those 3 minutes between Jade's call to Najee and Blaise calling 911, he was the only one with her. So he said, it is not my role to judge the credibility or whether or not someone believes Najee's version of what Jade said. That's for the jury. That's what this boils down to. Does the jury believe that Najee's version of events is what happened? Because other than that, nothing else connects him. So the judge is saying it's not if he had drugs, or if he had receipts, or if he bought them, or if he dibbles and dabbles in them. He was the only one there. So I can't just throw this out as a matter of law. Like there's nothing to cover this. He's the only one there. It's up to the jury to decide if they believe Najee Jackson's version of Mrs. Jade Benning's excited utterance, is what he called it. So we'll have to, it's on the jury. But he didn't say that the state was right. He didn't say that the defense was wrong. He didn't say the defense was right and the state was wrong. He said because he was there in that small amount of time and he's the only one there, and there's proof that he's the only one there, it's got to be sorted out by the fact finders.
I think we're here. I don't think we tested it yet. I just want to make sure we get it tested real quick.
And that's what this boils down to. Hannah, that's a good damn question. I don't know.
Yes,
He called it an excited utterance. I mean, technically, that's what it would be, right?
it's a PowerPoint that's on.
Oh, we.
Well, your apps are down there.
Yeah.
Now that's another question. Would I have enough to say that he did this?
The one other thing I think we're in
I think we're fine.
Especially when nobody can tell me how much she took. What could have been a little tiny concentrated amount.
Your Honor, about the jury instruction, Your Honor, reference 4210A. It doesn't have to be right this minute, but at some point when Your Honor's ready, we can have that discussion.
You want it in the jury instructions or not?
At this point, I think our position is we don't necessarily want it in unless there were substantial revisions to it, which we can discuss, but I think as written, we do not want that.
Okay. Well, it wouldn't all come in if he has motive and intent.
The other concern I would point out, Your Honor, is
A lot of
the
people.
language of that jury instruction.
I've seen a lot of long paragraphs in my
That's why I asked you if you wanted.
in
Or other wrongful acts.
Our position would be the word crime should be taken out.
Let me just say this. I had to fight myself tooth and nail to not go down a rabbit hole because y'all know every case I start to get crazy direct messages, and the direct messages in this case are even more weird than with the fake Adelsons. They are even crazier than the fake Adelsons, and we're probably up to like 13 or 14 messages as of last night. I just wonder. We're going to wait and see what the defense's case was, but it is of the mind of a lot of people. Yes, the defense is putting on the case. A lot of people that these girls are way more connected than let on. People have even, I think we tallied it up last night, four of the 13. Okay, 4 of the 13 are claiming to be family. 6 of the 13 messages claim there's a post out there of all the girls together. I didn't go look for it, but there's a lot of people who are very close to this case. And of the 13, only 1 claims to have some sort of connection to the defendant's side. All the other people are reaching out saying they're connected. Well, let me not say that. There's 14 posts. 13 are about the case. 14 was like, I'd rather watch you because the news about this is boring. So let me not say there wasn't there. That one is out there too. But this one, only 1 claims to be connected to somebody that knows Blaise or work with somebody that knows Blaise. But the rest of them, the majority of them is you're spot on. You're going, this is what's going on. The way that you're putting it is this, that, and the other. Or keep doing, you're doing such a good job. You're headed in the right direction. You just don't know. We live here. I've only had one person really say he's guilty. He did it. We know he did it, and still relies heavy on Apple's testimony. I didn't say Apple didn't say anything, but I just don't think it was what everybody claimed it was going to be.
Because there was no proof.
I don't know, that's what I said, whether the jury thinks discussing with someone else about facilitating or causing an abortion is a crime or not.
I think there's specific case law that's not.
So you want it in there if it says other wrongful acts?
I mean,
What word do you want in there?
the closest I think I think that was our position.
Go home and craft that paragraph. Sir.
If Your Honor wanted to charge that, I think we would be comfortable with.
I don't want to charge anything. It's up to you. I'm required.
Nobody's DM'd me that he was guilty, but it's some paragraphs in the comments that's like, and this, I'm like, I'm not saying I know the man is innocent. I'm saying I don't feel like the state has proven it. There's a difference between innocent and not guilty, and I don't think they've proved that he's guilty all the way yet. But it sounds like the judge is saying maybe the drugs have nothing to do with it. Buying them, going around them, touching them, having close proximity to the judge means nothing. But maybe this, as the judge is saying in his mind, this boils down to whether or not they believe Najea's excited utterance. Some of those comments are emotionally charged. I figured some of those comments are some of the people that are either close to or fans, close to the situation, fans of Apple, or, supporters of the family. And when something happens to your loved one, you don't want to hear fact or logic or technicalities. F all that. I know he did it. And it's just like, I know how that feels too. But that still doesn't change that because this is not my loved one, I can look at this and say the states are not the state. If this was my loved one, if Jade was my loved one, I would not be happy. every so often we got to go back into that innocent versus not guilty post. That's probably like my third or fourth one. We have an influx of followers or a emotionally charged or controversial case. Folks get into innocent. They think they're arguing guilty versus not guilty, and they're really arguing innocent versus not guilty. And we don't know who innocent. We can never say somebody is innocent unless we was right there with them. And even then, you can be right there with somebody and not know the intent. Did I tell y'all Murdoch was in court, is in a hearing right now?
Good morning to you, ladies and gentlemen. The jury, let the record reflect all of the jurors are here and present, and the defense wants to call Detective Smith. You'll raise your right hand and be sworn.
Do you swear the testimony you're about to give to be the truth, so help you God?
I do.
Okay, and brought the detective back. Mr. Roundup, not an edge up.
Good morning, Detective Smith.
Good morning.
Can you please state and spell your name for the record?
It's James Smith, JamesSmith.
And where are you currently employed?
The Metro Nashville Police Department.
And how long have you been employed there?
Nearly 13 years.
Did you ever have an occasion to get involved in this case involving Mr. Blaise Taylor?
I did.
Were you the first officer on the scene at the hospital, the first detective on the scene at the hospital?
I was the first detective to respond.
Did you ever call Andrea Browning and give her permission to go into the house?
Initially, I did not recall that who spoke. But yes, been talked about, yeah.
And would you have given anybody permission to go into the house? Is that something you would have done?
The only time that would be done is because I was not doing the search warrant, and the officer I had released, the officer, who initially was going to secure the scene or the apartment at that time. He had been released. The apartment at that time had been released, was no longer police custody to be frozen and such. So to give permission to anybody, it would have been after that fact that I can't say they can or cannot go in there at that time.
And just to be clear, do you have any documentations or recordings suggesting that you gave someone permission to go into the house?
I personally do not.
And would you have given permission for her or any friends to enter into the apartment?
If given permission, it would have just been family. I would have given them family.
And did you give family permission in this case to go into the apartment?
Based off the recollection that was given to me, it would have been either stepmom or mother, but Ms. Browning would have been the contact.
Would an email that you sent refresh or aid in your memory for your testimony here on today?
Yes.
He's trying to save the case.
Have you had the opportunity to refresh your memory?
Yes.
After refreshing your memory, do you have any recollection of giving Mrs. Benning's stepmother or any family members permission to go into the house?
Like I said, initially when I sent this email, I had no recollection or memory of giving anybody permission.
And when did you send the email?
This email was sent yesterday, Sunday, June 28th, 2026, around, it would have been 4 p.m.
And do you stand by that recollection?
Not with the information that was given to me this morning.
What information was given to you this morning?
You provided me a transcript. I still don't remember exactly giving the permission. Like I said, it wasn't in any documentation. I don't have a recording. The last recording I have was speaking or interviewing anybody was Mr. Taylor. But it was possible that since you gave me information showing this transcript that from Ms. Browning that I had spoken to her.
So,
Baby,
is your testimony today that you called Ms. Browning and gave her permission to go into the house?
I would say it's possible, yes.
Based on what?
Based off
I
The
can't.
information that was given
Now
to me
this
this
is
morning.
what make me say
And who gave you that information?
You
bullshit.
did.
And the information that I gave you was what exactly?
This is
Transcript
I
from
can, what the
Miss Andrea Browning testifying that I called her.
Was it Miss Browning or was it Miss Burks?
I'm not sure. I recall you saying Miss Browning.
It was Miss
fuck?
Burks.
Your memory just ain't
I'm
good
not
at
sure
all.
who Miss Burks is.
Did you ever speak
You-
to Miss Burks?
I'm not
Yesterday
sure
at 4
who that
o'clock,
is.
you ain't never
That
told
is
nobody
Mrs.
that.
Benning's
This morning
mother.
you may
I
have.
spoke to her on the phone initially at the hospital. Again, I don't recall speaking to her after.
And in that conversation with her at the hospital, do you recall giving her permission to go into the house?
No,
No, not at the hospital.
absolutely not.
Or any questions from Mr. Taylor?
With Sergeant Smith, correct?
Yes, sir.
All right. Sergeant Smith, the other patrol, the uniformed officers had spoken to certain individuals, including Ms. Browning, before you did, correct?
Yes, sir.
All right. And if the timing reflects that your conversation with Ms. Browning was approximately 1:45 a.m., does that sound accurate?
Yes, sir.
And again, that would have been after Officer Fish discussed,
Yes, sir.
interviewed her. And so at 1:45 a.m. and thereafter, you knew that there was not going to be a search warrant,
Yes, sir.
correct? And that there was not going to be any police presence at the apartment, correct?
Correct.
And so legally, whatever, orally, was there any authority you had to tell them that they could not go into Jade Benning's apartment, secure it, and deal with it?
No, sir. Once it was released, I can't say who cannot go in there.
Are you kidding? Okay. Okay.
Now, when you say released,
Uh,
has anyone ever actually been there to put
No.
up crime scene tape or stand at the door,
no, sir.
barring entrance?
No, sir.
And so whether you told her that 1:45 or thereabouts, or later in the call, you had absolutely every right to go there.
At that time, yes, sir.
They're trying to claim that the scene was technically released when they decided on night one that there would be no when DV talked, that third officer talked to Blaise, and then they decided they weren't going to do a warrant that night. They weren't going to go into the apartment. They weren't going to go do a search that night. Remember, all he said he created a warrant for, I believe, was, I think the next day he helped write a warrant, but he never went to the apartment. So what they're saying is that point between the domestic violence department not going and getting a warrant to the next day when it came up in the Hammy detective situation. Remember, the Hammy detective said DV dropped the ball. They should have secured that scene. So they're saying in between DV shutting it down overnight and Hammy picking it up the next day, that time in between there, the scene was released. You never secured it to release it. Okay. Now all of a sudden it's changing.
Detective Smith, to be clear, yesterday in your email, you said you did not talk to anyone?
I said, based off my memory and recollection, I don't recall or recount talking to anyone about giving permission to enter the apartment.
And you are aware that your conversation with Ms. Browning, do you know if that was recorded or not?
The initial conversation with Ms. Browning at Vanderbilt Hospital is any conversation, again, the last conversation that's recorded in my interviews was Mr. Taylor.
And you would agree with me that nowhere in that recording with Ms. Browning did you give her permission to go into the house?
No, at Vanderbilt Hospital, there was no recording of me giving permission to anybody when I was at Vanderbilt.
And
Okay.
sorry.
You go ahead.
And outside of that recording, you don't have any documentation or recollection of ever giving someone permission to enter into the home?
I don't recall having documentation, or like I said, Mr. Taylor was the last recorded interview I had.
And you do recall that a request was made for the scene to be secured.
I do.
Any other questions?
No, Your Honor.
Thank you.
Thanks.
Who's the next witness?
You.
We will call Sergeant Lindsay Fish.
Whew. He's simply saying it's possible he could have gave permission since they testified that he did. So it's not possible that they could be lying under oath. I guess it's also not possible when you think about it that Mrs. Browning can't recall, or she can't even renege good because she don't know what was said. She had conversations, but she can't remember who she was in conversation with or the context of said conversations. Then when the friend get on there, she said she called her son and asked for permission, not any other officer. So she said she told stepmom and bio mom, my son said we should do it like this. Then you get bio mom on there after dance mom, and bio mom says that stepmom called this cop, the first one that came to the hospital, which would be Detective James Smith, and asked him, can we go in there? So bio mom don't remember talking to nobody, but she remembers talking to everybody, but she remember having had a conversation, but don't remember what words were spoken in that conversation. Dance mom didn't call that particular cop. She called another cop, her son, allegedly out of another state, and asked for permission. Bio mom says she knows that cops gave permission because she was told that. By who? Oh, by stepmom. Stepmom don't remember shit. And now you're saying stepmom said, bio mom said stepmom called the police and asked for permission. And the police is saying, now the testimony that Detective Smith is giving today is that he called stepmom. Bio mom said stepmom called you. Now you saying you could have possibly said it since she testified to it when you called her. The fuck? And it's not like it was your old testimony a few days ago, or it was your old testimony at the bond hearing, preliminary hearing, anything like that. You are saying that as of yesterday, we were just in court Saturday. So less than 24 hours after court ended on Saturday, you sent the email, said, I ain't talk to nobody. I ain't tell nobody shit. I ain't say nothing about giving nobody authority at 4 p.m. And less than 24 hours later, even less time since from Saturday to Sunday, from Sunday to Monday, you walk up in this motherfucker 10, 12 hours later and say, well, maybe I could have if you, maybe since somebody testified to it, instead of saying, I didn't give nobody permission.
Do you swear the testimony you're about to give?
Phone records. Come on, little mama. Bring me the phone record. It better be a phone record that show that stepmom called this police officer. Period.
Good morning.
Jesus.
Can you please state and spell your name for the record?
Lindsay Fish, Lynnsey Fish.
And how are you currently employed?
I'm a detective with Metro National Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. Jade Benning at Vanderbilt Medical Center?
I did.
And would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
The court officer has handed you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body worn camera from that night?
It is.
And is it a fair and accurate depiction of from your body worn camera that you were wearing that night?
Yes.
Has it been altered in any way?
Doesn't appear to be.
Y'all, at this time, I would ask that this be entered into evidence as a defense exhibit 3, I believe, or what?
Yeah, we're just putting it in that.
55, I'm sorry. Permission to publish on?
Okay.
Can you describe what you see in this scene here?
This is the entrance to the ER of Vanderbilt Hospital.
So this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
Mask.
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night.
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Did you ever have an opportunity to speak with a Miss Brown that night?
Yes.
Mom did not.
One second, I want to go right back to exhibit number 55.
Y'all know what that means.
Can you tell me what, if anything, that security guard is wearing on the face?
Real quick. Clearing up, there you go. Clearing up Keontae and Najea's interaction at the hospital, proving that Keontae is a lie. He was not in that lobby. He was actually outside in that parking lot and he never came in. Keontae said that Vanderbilt had no metal detectors. He said that, what else was it? He said that maybe security was slipping on their pimping because he came in. So they just pointed out that not only is there a security guard right there at those metal detectors, but there was at least one and more backup security right there. And they was on their P's and Q's right then and there. The next thing he's also showing is that wasn't no wide open area. If you look at that, that looks like a very narrow area. Therefore, there's nowhere to slip around past security. But my thing with Keontae is even if he did slip past security, because I don't put nothing past nobody, why he able to be a cat burglar? If he can slip in and out of there, he can slip in and out that apartment. So I don't think that was a good thing for him to try to prove, but okay.
The mask?
Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with had to wear masks?
Yes.
Now, I just want to try to orientate the jury to...
Orientate, Lord.
You say you were one of the first officers on the scene that day?
Correct.
Would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you
Roll
recall?
up closer to the mic.
And do you recall while speaking to her that Miss Burks got on the phone?
I don't know who Miss Burke is.
Miss Burks would be the mother of Mrs. Benning.
Yes,
She did in fact get on the phone,
yes,
and you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you
Bam.
inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present
Yes.
and Ms. Burks was on the phone?
Yes.
No further questions.
Question.
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen, is that correct?
I do.
Okay. And if your body cam reflects you speaking to Ms. Browning around 12:37 a.m., is that accurate?
I don't know the exact time. But when
But it was prior to Sergeant Smith.
yes,
And to your knowledge,
Play the damn body
the
cam.
National Police Department was going to go out, conduct a search warrant, and freeze the scene.
I knew that that was a possibility.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay, would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there?
Objection, calls for speculation. The witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro Nashville Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back to the apartment?
No.
Those were my questions, thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes. That the investigation was why the investigation was happening.
Fair enough. No further questions, John.
Any other questions?
No, sir.
Thank you. Good step in and be excused.
I'm sorry, guys. My flappers are beginning to be gasted here because I know you're not saying that because the investigation was lacking, and because the investigation lost the step, something wasn't done in the middle of the night. You're saying that it was oh well, the scene was fine. What? Yeah, please explain because I'm lost. Okay, so what? The last officer apparently sent an email, Detective Smith. Okay, so Bio Mom testified as the last witness on Saturday afternoon, saying that the reason why they went into the house is because the first officer, and then she said she used officer and detective interchangeably, but she said the first officer and or detective that stepmom had talked to while she was on the phone on her way to get to her daughter told her that they could go into the house. Okay. Stepmom don't remember nothing. Dance mom believes that her son can tell her what to do from another state. And bio mom said, oh, they told stepmom we could. First officer, first detective. So they just brought in the first detective that got there. Yesterday's email said, I ain't tell nobody shit. Today, he's saying possibly I could have, but I wouldn't have. I don't have documentation that I did. I don't have any audio that I did. But if somebody testified that I did, then maybe I could have. But as of yesterday, Sunday at 4 p.m., I ain't tell nobody shit. So then they said, okay, cool. First detective out the way. Let's bring in the first officer. Did you tell anybody that they can go into that scene. Now, remember, bio mom and stepmom have stood on the grounds that there was no investigation happening, that the police was moving to, remember Dance mom said police wasn't doing shit, they was moving too slow. So because the police wasn't doing shit about Jade, and they were, what she say, me and Bridget were pissed. Bio mom and Dance mom were pissed that the police weren't doing anything. There was no investigation. There's nothing going on. So they decided to go into the apartment. Now, this is the first officer that's on scene. Her right here. This is the first officer. So we already got first detective out the way. And it sounded like he tried to save the case a little bit. But first officer says, I told them straight up, this is a possible crime scene. We need to freeze that apartment. No one in, no one out. Something's going on. Detectives are on the way. We're on this. So bio mom saying there was no police there when she got there, she still was on the phone on speaker when this officer said this is an investigation. Dance mom said nobody was doing an investigation. We knew nothing about it. They didn't do anything. I had to call another police department, my son, out of state. That's not true, because you were on the phone with your best friend the whole time, and she was very much aware before she even arrived in Tennessee from Arkansas that this was an investigation. Now, the only one that can claim that they might be right or wrong or half right or half wrong is stepmom, because stepmom didn't agree or commit to any one conversation. She said she don't recall. She talked to people. They was talking. What they talked about, she don't know. Might have been. Can't never remember who all was in the conversation. She can name at least one person maybe that was in the conversation if you tell her that was who was in the conversation. But she don't remember shit. So now you said first detective told you. He's saying I could have, but yesterday he said that he didn't at all. And now this officer is saying she told them off rip. There was an investigation. Freeze the scene. Don't go in there. And we're on this. So bio mom lied. Dance mom lied. And why we're lying, I don't know. Because that's stupid to lie about that. Especially when it could possibly be on body cam. And I don't know why they're asking her all these questions when they could just play the fucking body cam.
Who's next?
The defense calls me MJS.
Well, this will put us at witness number 3 of a possible 10. So we about 30% through this thing already, and it's not even 7:43 for me. So what? It's 9:43 there.
We'll move to Dr. Peters.
Moving and grooving. Moving and grooving.
Like we approach.
Okay.
What you need to approach about this witness for? I'm loving her and her cream, even though when in the child case, Mr. Man wore that cream suit, it wasn't good. Maybe I think it was lilac. Ooh, girl, you blind. Ooh, them some thick glasses. Jeez. I can't talk because I'm blind too, but that's why I don't wear my glasses like that. Because when you look through them, Jesus. It was lilac. There it go. Maybe that's why. Because I've been loving the cream. I have been loving the cream. I'm also interested in a good cross, because the DA usually is calling all the witnesses. They don't always get a good cross in, right? But 10 witnesses, we might see a good cross. And sometimes the DA, we may not always see them in action, but if they get real passionate about a case, they can be mean as a junkyard dog, So I really want to see her be able to cross, because unfortunately a lot of the other stuff meant looking like she was kind of like telling or whining, and that's not cool. That woman got a whole degree. My godmom ain't shit. She said that she gonna send me a walker, y'all. I don't know if y'all got to hear this. Now she gonna send me a walker. Oh, it ain't working. Okay. Now, for all my folks who was ready to leave their knees by the cross because T.I. came out with that "Let Them Know," and then Trick Daddy Dollars had a verse, and all the uncles was dropping songs for the summer. If y'all have not heard that T.I., T-Pain, and Jeezy, grease your knees, okay? And then Mr. Percy finna take that whole verses on tour. Then, in the most auntie fashion, T.I. then sampled Keith Sweat's "Don't Stop the Love." Baby, we just gonna need walkers at the end of the summer.
Go ahead with your question.
Thank you. Could you please state your name for the record, please?
My name is Nia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee, I'm coming up on 1 year.
And did you recently move to Tennessee?
Yes, last year.
And what company do you work for in terms of for investigations?
Out of Texas, I work for Willis & Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes.
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
Yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have.
Hold on now. What's this?
Something else, not to put photographs with me.
Should have photographs.
Yeah. I believe you should have that photograph in your packet there.
Yes.
Okay. Do you recognize that?
Yes.
Okay. Can you find that in your packet, and can I get my copy of that?
I'm sorry, this picture is not in my packet.
Okay, that's fine. Do you recognize that photo that you
Yes.
took?
Yes,
And what is that a photo of?
it is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay, now I have it back so that I can publish to the jury. Is it in the same fashion in the way that you photographed?
Yes.
And are you the one who actually photographed this?
Yes, correct.
Right.
Your Honor, at this time, I'd like to publish.
Don, something up. What is this?
Is that in fact the marquee for the Ontario apartments or condominiums?
Okay.
Yes.
Have you had the opportunity to view any photographs from 2023 or February in regards to the Ontario apartment complex?
Yes.
And is that marquee in the same fashion that it was in 2023?
Yes.
Could you please read for us the address here at the bottom of the sign?
It is 1522 through 1550 Lebanon Pike.
Thank you. Did you have an opportunity to go out and look to see apartment 107 where Ms. Benning was living at the time?
Yes,
And were you able to ascertain whether or not Ms. Benning's apartment had windows?
yes,
Where were her windows situated?
on the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, as a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes,
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
it would have been, I'm not sure,
Mark,
I can mark on here, sorry. It would have been this one.
okay. And I want to now show you another photo. You can clear the screen.
Oh, sorry.
Y'all, what is happening? This got my nerves bad.
Got it.
There you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say, parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point,
Yes.
okay, it would be this way.
And did you take this photograph?
Yes.
At this time, we would offer.
So do they have issues with people coming over there? Get to it, because my nerves is bad.
If Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
Depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or to where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
Is that also behind Ms. Benning's apartment and the view that would be out of the only window in her apartment?
Yes.
And what about this photo?
That is another angle showing the trailer service repair business.
Was they having break-ins? But so there would be a reason for the camera to be back there, I guess is what they're getting at. Let's see.
Did you have an opportunity at our request to do any research in regards to the son of Ms. Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Ms. Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer.
We are going to check the relevance of this.
No.
There's been testimony that a police
No.
officer gave Ms.
Right,
Franklin.
you asked all about it. A police officer told her to do X, Y, Z.
Correct. And if I may, I would like to,
So what do you want to ask?
did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the question,
That would be based upon hearsay.
Care to be heard?
Yes, it's not hearsay. She did the record search herself, Your Honor.
Well, I know that, but would the information be an out-of-court statement offered for the truth?
I don't believe that if you are doing, nobody told her anything. She researched to see whether or not a T-code existed
So
for
you want to litigate whether the gentleman was or wasn't a.
Y'all said a police officer told y'all how to go in and collect.
I object. On the basis.
Why don't y'all want her to say it? Because y'all know he's not. She lied.
Effect on the list.
Absolutely.
Okay, it is hearsay. I'll sustain the objection.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
Do you have someone that you're calling from the police department saying he wasn't a police officer?
Yes, sir.
You do?
We have researched and looked
No, I'm
at.
saying, do you have a person from that department?
Ms. Gutierrez called that
I'll
department
sustain the
directly.
objection.
And Your Honor, if I may, through this witness, introduce this judgment.
I certainly object to that.
Okay. The judgment about.
It's a certified copy in regards to this.
Jury is in there.
It's a certified copy.
I'm not sure which one,
Yes.
we have the one,
Here we go. I gave it to you last, but I'll give you one.
but like we approach.
Okay.
The jury heard that. That boy is not a police officer. I don't care what you say. Toothpaste cannot go back in the tube. The jury just heard. Do you have a person that called you that said he's not a police officer? Yes. Who is that person? Well, she called the police department and they said she did the research. So the jury just heard that and he said, I'm going to sustain it as hearsay. He ain't no damn cop. Ain't nobody told you to take your ass in there. Y'all lied. So first y'all said it was the first detective. He said yesterday in his email, in his own words, hit send, that no, the fuck I didn't tell nobody to go up in there. So maybe not first detective. Let's go with first cop. I'll give you that one. First cop said, I ain't told nobody. Take their ass in there because even before anything went down, I said, detectives on the way. This is an investigation. Freeze it. No one in and no one out. And now here we go. We got a private investigator that not only went there, but says, hey, there's no reason for what they say. There's no reason for her to ever have that camera in the window. Oh, there's a whole business and a whole drive back there. If that's the only camera she got, then that's the camera she got to move. If that's what the live view that she wants. He ain't no diva. Listen, he ain't no cop. He's not a cop. So whether you said the first detective told you, the first officer, if you mixed up the first officer with a detective and said they told you, whether you said it was a cop from another jurisdiction told you, after the lead investigator said, I'm aware that a cop from another jurisdiction out of state told them that it was okay to go in there. And he said that was okay. Well, what if it wasn't no fucking cop? Why are we lying? Why are we lying? Listen, y'all, they got me on the wrong day because I'm on my second cup of coffee. Okay, I've been up since 4:30. When I say boys' suitcases are packed, both of them. I even got my suitcase packed and working on my personal bag. Big Unc started his packing last night after the boys went to sleep because we can't let them see us packing. Then I made a sub rings chicken bacon ranch for lunch while I was
Any other questions?
lasagna soup. So Denver got his lasagna.
Okay, and get those, I think.
Got the whole house out clean. Roomba gonna do
5
the floors that I'm
photos
a mop
after
today.
that.
I am working. Tomorrow ends the month and I'm on track to be done today.
Get those.
Okay. I want to see. Give it to me. Give it to me.
Collectively. Okay. any
I'm
other
good and ready.
questions?
Good and ready.
This witness and this
Okay. Any questions from the state?
I request, James.
Any statements you have from this particular witness?
No, Your Honor.
Okay.
May I see the exhibit,
The photos?
the collective exhibit? Yes, sir.
Yeah, that's all right.
What was the judgment? Okay. Y'all know I usually don't fool with stuff that's not inside the courtroom, but I kind of want to know what that judgment was. Worth a damn.
I believe you said that you were employed by Covert Investigations. Did I get the name right?
Yes, and Willis and Associates.
Okay, okay. And is that based in Texas with an office here, or is it totally Texas?
The Willis and Associates firm is based out of Houston, Texas, and Covert is here out of Nashville, Tennessee.
Okay, and so when were you retained? When were your Covert or?
Are you asking if I've been retained through which firm?
Yes.
Or, okay. Okay, well, I've been retained under Willis and Associates since before my move to Tennessee on this case.
I was just trying to get the time line down. And with respect to this particular case, when were you retained?
Covert Results was retained at some point on the case after Willis and Associates, but is my understanding, to my knowledge,
When were you retained on this case?
I
Start billing.
I'm billing under Willis.
When did you start?
Oh, early 2024.
And what is early 2024?
I would say probably March.
Do you have records of that?
Yes, according to timesheets that I turn in, correct.
Do you have those with you?
I do not, but I can get them if needed.
Did you have any other involvement as an investigator with this case prior to, when you say early 2024?
No.
Were you familiar with this apartment complex prior to being
No,
retained?
I was not.
Now, Ontario is an apartment complex on Lebanon Pike here in Nashville, Davidson County, Tennessee.
Mm-hmm. Yes,
And this sign is at the entrance, correct?
at the entrance, correct, main entrance.
And Miss Benning's apartment that you were directed to
Mm-hmm.
is essentially in the far back corner, correct?
I would say the center far back corner building.
Well, council seen this photograph. They put this view. Actually, it might show better, but you have the ability to touch this.
Mm-hmm.
Where is the sign that we just saw?
It would be right about here.
Okay? And Ms. Benning's apartment would be in that general area, correct?
No, that would be the entrance to the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what
It would-
part of that corner it is?
Probably right here towards the center, somewhere in that section.
another one that's a little bit further out. And this is a larger view of the businesses in the area, correct?
Yes.
And the truck repair place is in the top of the picture, is that correct?
Yes.
And now on this picture, could you circle what you say is Miss Benning's apartment?
You want me to circle it on here?
Yes, please. And again, circle the entrance.
Where the marquee would have been?
Yes. Thank you. All right, tender these photographs as the next one, 58, 57.
There are two,
There are two, yes.
okay, just make a collective 57.
And this is part of exhibit 6 that we've previously seen.
At this point, defense, call Ms. Franklin back up there and ask her for
You
son as
circle
a police
again
officer.
what you say is the window to Ms. Benning's apartment. Now, the next window over, is this also not a part of her apartment, or do you know?
I don't recall. I have to look at a bigger angle. But it is possible.
And obviously, as we see in this picture, the blinds are closed all around, correct?
Yes.
You never went in this apartment, did you?
I did not.
And the photographs that you took, do you know when those were taken, the date and time?
Can I look at my notes, Your Honor?
Sure.
On June 21st, June 24th, and June 26th, just this recent, I visited the property.
This month,
Correct.
had you visited the apartment complex prior to that?
I had not.
Judge, those are my questions. I'll
Okay,
submit these back.
Any other questions?
No, Your Honor.
Thank you. Next.
At this time, Your Honor, we would submit a judgment.
Okay,
The judgment for Keontae Jones for a conviction of theft on September the 1st of 2022.
okay. Let's mark that as 58.
Oh.
The defense will call about the shooting Peters, Your Honor.
Okay.
Yeah.
Oh.
We approach.
What's the theft gonna do? Or y'all just proving that they didn't look into him and he got some sketchy stuff? The only thing I can think of, Britt, of like the point of that line of questioning, doing it from an aerial view makes it look like it's further away than what it is. But the pictures that from the previous one, I don't know what that was for. Keontae apparently be touching stuff that ain't his. Now, the only other thing I can think of they may do to solidify this on a human level is wait until closing arguments and say he ain't no diva. She came here and told you that a cop told them they can go in there, but her son ain't nobody's cop. He might have been watching Law and Order at that time, but he ain't Benson or Stabler. Keisha. Technically, he said not to his knowledge. He said not to his knowledge.
About to give to you the truth, so help you God.
He didn't say never. He said not to his knowledge. Maybe his knowledge is incorrect, but he said at the moment.
Spell your name for the record.
Sheila Peters, SHEILA PETERS.
And how are you currently employed?
I am an associate professor at Fish University, and I also operate a private practice.
Private practice in what?
Clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What's
You're all right, Jack, you're not calling her as an expert.
This is background information now, if I may.
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree, as well as a master's and a doctorate.
From where?
Undergraduate degrees from University of North Carolina, Chapel Hill. My master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician.
And in that role, what were you expected to do?
In that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress
I'm not mad at
and
this line of the witnesses.
what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
Your Honor, I object to that.
Impression.
We're not having.
They were co-workers, Your Honor. I'm just asking her what was their impression, her impression of Mr. Taylor.
With the time frame.
You asked the fool that didn't know nothing about.
When did you ever interact with Mr. Taylor in 2022?
Just cordial hello.
And did you ever interact with him in 2023?
Yes.
And what was your interaction with him?
I was asked by the GM.
Your Honor, objection,
Okay.
hearsay, and this is in a professional capacity.
If I may, Your Honor.
What is your question?
My
What?
question
You
is,
didn't
did
finish
you
the
interact with
objection.
him at all in
And your answer is
2023?
yes or no?
Yes.
Okay, she did.
And what time frame did you interact with him?
It was in March,
Was it once or more than once?
twice.
Do you recall any dates?
Yes.
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what, if any, impression did you have of him?
And again, Your Honor, I object.
Okay. To
Your
get
Honor, if I
an
may.
impression, she'd have to be declared an expert in what?
I'm not, I'll rephrase my question.
Okay.
What, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a
Okay,
clinical
she
assessment.
can describe his demeanor. What was that?
He was concerned about the situation.
That would get into hearsay.
Yes, sir.
So,
She just described his demeanor as concern, Your Honor.
okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
What,
March
did-
8th.
March 8th.
Yes, sir.
And what was his demeanor like when you interacted with him on March 8th?
On March 8th, he was troubled because Ms. Benning,
Okay, see, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something.
Do you know why he was troubled?
And Your Honor, objection.
That would be based on hearsay from your client.
Miss Sheila about to say something on that mic. I'm
She
just
said she
saying.
was in trouble. So what's your next?
They don't want this out.
And
I think the state objecting like this looks worse than whatever
were
she
you there
wanted
to
to say.
support him?
yes.
And how did you do that?
Your Honor, object to the relevance of her support.
Your Honor,
Did you-
Laura, normally I hate when the defense puts on a case because they don't have to say anything. But in
Yes.
this case, I
Okay.
feel like
What's your next
something
question?
needs to be said because
and
otherwise
as a
we're going
result
off
of your
a bunch of
interaction with him on March
consistent statements.
8th, what if anything that resulted from that interaction?
Your Honor, I object to that.
Let the lawyers. step
And
up.
some are even coming from detectives. And most people regard the word of a cop or a detective. They give that more weight than a lay witness. And I don't like that. I don't like it. I don't like when people play games like this. I really don't. Why do you care? Y'all wanted everybody to know that he went to work. He said nothing. He did nothing. He didn't act like anything was going on. And even if he did act like something was going on or said it was family stuff, it wasn't enough because who in their right mind would go to work if their girlfriend was on life support? Maybe a person that wasn't welcome at the hospital. But even for whatever reason, if you knew for a fact that he actually did talk to a psychologist during this time, then you know that that's a crock of bullshit that he just went to work. We all go to work and put on a certain type of face. You can't go to work and cry on the phone with a customer. Work don't care about your life. She's not an expert witness. That's why they're running into this. They should have qualified her as an expert, but she's not an expert witness. She's just coming as a co-worker like the other
Mr.
person.
Taylor remained with the Titans after March 8th?
I don't know.
Do you know where did he go, if anywhere?
Nicole, on which
Sometime thereafter, he went home.
Do you believe that was a good decision?
Well, Your Honor, whether she believes.
Okay, I'll sustain the objection.
When you encountered Mr. Taylor on March 8th, was there anything out of the ordinary with him?
It's been asked and answered.
No, it has not. Out of the ordinary.
Anything out of the ordinary unless it comes from hearsay.
Well, based off of the impression that she would have gotten in observing him and interacting with him, what his demeanor may have been.
She's described that as trouble.
She did, but not in relation to
Not-
not in relation to what would actually happen when he left. So I think it's a little nuanced there, Your Honor.
Okay, well, I'll sustain the objection.
During your time at the Titans, did you ever have any personal problem with Mr. Taylor?
No.
No further questions, Your Honor.
Any questions from the state?
No, Your Honor.
Thank you, ma'am. You can step down. Who's next?
At this time, Your Honor, this defense will call Dr. Melissa Jerry.
Jerry.
Your Honor, at this time, pursuant to previous discussions, safety request carried out, because we have no report.
All right, ladies and gentlemen, the jury appeals steps down the hallway just briefly.
Did she even do a report?
Hey, what is it? Hang on a second, man. What is this witness being offered for?
This witness is being offered in regards to the NMS reports. To the NMS reports that were tendered to the defense in regards to the blood and urine of Ms. Benning. And the testing of that blood and urine that went to the cause of death in this particular
And
case.
you're wanting her declared an expert in what field?
And laboratory testing of toxicology.
Is she a toxicologist?
She is.
Okay. And the state's objection is what?
That you
We
don't have a
no
report?
We have her CV, but no report to know what the parameters of her.
You have a report from her?
She didn't give a report. She looked at the
No.
evidence.
Do you have any
Do you have any
report?
others?
No, I'm asking you, do you have any information from her that would be considered a statement?
I don't, Your Honor. I asked
I'm
her.
not talking about you, I'm talking about your firm, your counsel.
No, I am the firm counsel. We don't have anything. I've met with her on several occasions. I have my work product, but I don't have any notes from her.
So she's never emailed you or anything like that?
Of course. But it
Those would
wasn't a
be
report.
her notes.
I don't have notes from her. She may have emailed me in regards to what time is the Zoom call or are we?
She doesn't have a report.
No. she
So
didn't.
what do you want me to do?
We would hear her testimony out of the presence of the jury for the court to determine whether it will materially assist the jury and basically a companion hearing.
So you're thinking this particular witness isn't qualified as a toxicologist?
No.
I was about to say, now what are you trying to say?
What she testified about, that we have no knowledge. She just now says about NMS, well, if we'd had a report, we might know whether to have had
Some people don't do reports for
unless,
tactical reasons.
yes. And here, since the witness has a notebook with her, that might be some, it's nothing else, Jake's material that we would.
What is all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay. Do they have a right to look at that?
Sure.
How long do you need to do that? See, the jury's back there thinking, I won't say what they're thinking.
Prior to the last trial, when we had this come up, certainly recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report,
I don't know if I said that.
as well as counsel saying that they were only intending to call Eric Devlin.
Well, I don't know who that is. I mean, this person's listed on this witness list.
We have provided the state,
Lena Gill.
we have provided the state a full list of all of our experts and a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. DeGarry may have, I don't have those notes. And they are more than willing to look at whatever notes that she's made in order to assist herself in this testimony in the same manner Dr. Lethune had to give me notes when she turned over almost 10 pages of notes to
Do
me.
you have all of your notes pulled out?
The records.
Do you want to look at those? The state want to look at those before she testifies?
Yes, Your Honor.
Okay. Run copies of those, Mr. Evans. And of Dr. Bartolome, Dr. Larkin, and Dr. Lindsay, how many of those do you plan on calling?
All of them.
Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. There were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists, so we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us
Okay.
to do that.
Could you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right, go ahead and do that. How long is the state meeting?
We were very much under the impression, based off of Your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithun stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said when we asked Your Honor to exclude them if they
I don't
did
think I
not
can
provide a report.
exclude them when they don't provide a report. The rule talks about turning over a report and discovery if there is one.
And Your Honor, the state didn't give us notes of all of their experts.
They got the
I don't know.
litigation packet, that is their
You said you had 1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
Do you want time to get Dr. Carney or anyone else up here?
Judge, our toxicologist is in Pennsylvania.
We never said we
I
want.
didn't ask you to say anything. So what do you want me to do? Declare a mistrial? Delay it till next Monday?
Would Your Honor allow us to contact Dr. Mithun and see if she is available to watch it by video, so we can at least confer with her after this witness testifies? If she was present today, she would be allowed in the courtroom.
Sure, she can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if she's available to do that?
All right, get those other notes. We'll be in 15 minute recess.
So you sat there all day on Saturday, listened to them say that they were going to have maximum of 10 witnesses, saw that witness list, had 3 to 5 doctors on it, and you just sat there rubbing your hands together and rubbing your feet together like you had a good old dessert, because you was just going to sit there and wait for the judge to say, they can't testify. He can't testify. She can't testify. They can't testify. Ain't going to testify because they don't have a report. You really thought that that was what was getting ready to happen? You really think that people that have passed the same bar as you would actually submit a witness list at the, in your mind, high probability that they're never going to testify? That's like a little kid waiting in the wings for their mama to tell their brother no. So you mean to tell me you'd rather get some sort of sick satisfaction that he could not put on a witness based on a technicality than to win this shit based off of your case alone? You knew those people were testifying. You knew those people were toxicologists, psychologists, and whatever other is coming. But you thought because somebody changed the report, added their signature, that that's good enough. That's considered a report. But if somebody don't at least amend the signature on a report, then they shouldn't be heard. I'm sorry, but if I was an attorney, I would want Blaise to bring everything. I would want Blaise to come guns blazing. Bring your best, because I'm about to put your ass away. I want you to defend this to the utmost. I want you to have the best attorneys. I want you to have everything you got, because whatever you got ain't going to be good enough for this case. This is why, before all the bullshit, I said I was a Fonnie fan in the very beginning when she first took over. Because one thing Fonnie Willis' crazy ass used to say is, I will give you my whole case. If you can beat me with my case, I don't have one. But the fact that you don't want it to come out that that woman's son is not a police officer, why would it matter if she wasn't lying? Why would it matter? And furthermore, why would you even prep with her and let her get up there and say that her son was a police officer when you knew that somebody could take that, twist those words, and fuck it up for Jade? But instead, you rather sit back and say, ha ha, chitty, 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 nana, nana, boo, boo, your expert can't testify because they don't change signatures on reports. But I guarantee if one of their experts would have came up there and said, oh, I just re-reviewed this, and because I re-reviewed it, I changed the signature on it, so technically now it's my report, they would have been, the state would have argued that. The state would have argued that down. The state would have argued that down. I don't even understand why y'all had Mr. Smith go on there and try to backtrack on the email that he sent yesterday. You already had the lead investigator say that the scene isn't contaminated, whether they went in there or not. So why would you sit up here and argue back and forth whether or not the scene was secure or not, whether it was released or not, whether or not it was okay for somebody to go in, whether or not a cop told them? What does it fucking matter if the lead investigator said the scene was not contaminated? Lets me know you have no confidence in your fucking case. What you miss? Caleb, when you come in. So far, we've had a motion for acquittal presented by the defense, to which the judge said not, basically, since Blaise was the only person there, it's not his role to judge the credibility of how the jury feels about Najea's account of Jade Benning's excited utterance, or you did this, or what have you. That's for the jury to determine the credibility of and whether or not they want to go with it. We had Detective James Smith, who was the first detective on the scene, not the first officer. We heard from him during the state's case. But in this case, apparently yesterday, he wrote an email to the defense that said he ain't never at no point in time, ever at any point in time, said a damn thing about giving anybody authority to go into that apartment. But then after somewhere between 4 p.m. yesterday evening and this morning, he turned around and said that if somebody testified to it, and since he saw the transcript that somebody testified that he was the person that told them that they can go in there, then he can only say there's a possibility that he said it, but he has no body cam footage or any other type of documentation that says he told somebody they can go in there. So then they took a step further, because we know bio mom said stepmom talked to the first officer or detective, whoever was the first officer or detective that she talked to, told her that they can go into that apartment. So we get past the first detective and they said, okay, well, if it wasn't you, or according to your email yesterday, it wasn't you, then they moved to Sergeant Lindsay Fish. Sergeant Lindsay Fish was the first officer on scene before any detectives. And not only did she say she didn't tell nobody they can go in the scene, but she said that stepmom had bio mom on the phone, and she told them that there was a situation. She told them, or confirmed for them, that there was an ongoing investigation. She said that detectives on the way, the apartment should be frozen, meaning no one in and no one out, and that's apparently on her body cam. Now, remember, Dan's mom said her and Bridget, her and bio mom, were upset because there was no investigation. Nobody said there was an investigation. The police weren't doing nothing. They were pissed. And so she called her son, that was a police officer in Arkansas, and verify with him how to go into that apartment by honoring her friend, but still finding information for Jade. So they had a tussle about whether or not the scene should be frozen. She said, and this particular officer said all she knew to her knowledge that there was a accusation of a possible crime, and therefore nobody should be going in and out the department. Now, what the state is actually saying on cross is that apparently DV put in a request for a search warrant. The search warrant was denied, and she has no knowledge of that, but she did say in general, if a search warrant is denied, then the scene may be released in that regard. And so they're trying to justify these folks going into this scene even after a lead investigator said it didn't contaminate nothing. But defense comes back through and said that you knew it was a possible crime, you knew something was going on, and you informed them of that. And they did. Next up was Yan Gutierrez, private investigator in Tennessee and Texas, recently moved to Tennessee in the last year, and she went to the exterior of Jade's apartment, and she was able to give us pictures and info in regards to that back window where the camera was found. She pointed out that there is a parking lot back there, a driveway or alley. She described it as both. She said, or each time. And there's also a business where they repair trailers right beyond that fence. So it's not like, remember they said her camera wouldn't be back there. It's not looking at nothing. It could be looking at a car. It could be watching the back. It could be watching her patio. It could be watching that business. It could be watching activity. It could be watching somebody else's car that could park back there, or activity back there if there is some. So that was the camera. And then they cut her off when apparently she reached out to see if Dan's mom's son was actually a cop. The state objected like crazy, but it sounded like we heard pretty much he ain't no damn cop. Okay. They would not let that come out, and they would not let the judgment come out while she was on the stand. When they did the cross tried to play like she was a Texas firm in Tennessee or a Tennessee firm in Texas. They even said something about wanting her timesheets to know when she was retained, even though she maintains that was early 2024. Was not familiar with this apartment complex prior to her doing her research. And then they used aerial views to orient the jury of where the entrance sign was, where Jade's apartment was, and then in the back where the trailer or other businesses were. Only thing that did for me is the aerial view made it look like it was further apart. So what would the camera be looking at? But those pictures she took from the angle of the window from the exterior of the apartment, no. They did submit a judgment that said Keontae was convicted of some sort of theft in September of 2022. That's all we heard about that. We had Dr. Sheila Peters on. She's an associate professor in private practice. She has a private practice. She's a clinical psychologist, which they objected to her even saying anything about her education because they said she's not an expert, but we did get out. She got her master's and her PhD from Vanderbilt, so don't play with Miss Sheila, okay? We also found out that she was a support and did assessments for the organization of the Tennessee Titans. So even though they objected through all of it and tried to call it hearsay, she did state that on March 3rd, she was concerned for Blaise. She did talk to him on March 3rd and March 8th. March 8th, he was troubled, but she said by that time, and they objected to that. So get ready to say that by that time, Jade had passed away. She said he did go home on March 3rd. So he didn't stay at work. He ended up going home, and they objected like crazy till we ended up at the bench. And then she basically only got to say after that, there was no personal issues with Blaise. There was no redirect on her because Mama Sheila looked like she was about to give them the fucking business. Okay. Next, we thought we were going to have Dr. Melissa Jujeri, but then we got into this tussle. I don't know if you've seen it, but we got in this tussle of whether or not did Dr. Jujeri or any of, it sounded like they named another 2 to 3 doctors that will be coming, that will all be experts, whether or not they should be allowed to testify, because the state seems to believe that the judge made some preliminary or pretrial motions or pretrial rulings that said if your expert didn't have a report, they couldn't testify. So it looks like they were relying on that. And when the judge said, well, if they didn't write a report, sometimes that's a tactical thing. They did not write a report. They're relying on the toxicology reports, the stuff from the NMS labs. Couldn't even get that out. And then, so if they're relying on this, and she's like, well, she's got a notebook. And she said, okay, it's my notes and the labs that I received. And judge asked, can the state see them? She said, absolutely. And the state really wasn't happy with that. They don't want the notes. It seems like they were more prepared for the judge to bust the defense bubble and not let any of their experts testify. And we can see that in the fact that they didn't even give Dr. Mithun a heads up that, hey, because we know with the rule of sequestration, they let family in and experts to hear the other side's experts. So they didn't even have Dr. Mithun like, hey, come back on Monday, because they got a whole list of fucking folks that are experts. They got like 4-5 experts on here that we know of, and we may need you here to rebut this in case we got to call you back and do our rebuttal case based on these experts. It looks like the state was absolutely wholly relying on the judge kicking out all of their experts because they didn't even have their expert come back. Well, they can testify, and there is please believe that you are aware of your attorney's strategy prior to them doing it, right, Hannah? So they are willing to testify as much as you're willing to let them testify. And at this point, if I was Blaise, yeah, tell these motherfuckers I came to see you, because they trying to paint this picture like I didn't give a fuck because I came to work. But I came to work and talked to the psychologist that was at work. And honestly, that make more sense than anything because that one was free. Instead of making an appointment, waiting, and using my damn insurance and shit. You have to sign a release. Yeah, they won't just testify. Stay ready so you ain't got to get ready. Yeah, I would have never let my, especially if you got a bunch of, especially if it's another toxicologist coming. I'd have had my toxicologist sitting there. You want a psychologist coming? I'd have had a psychologist sitting there, because at the end of the day, what I'm not going to be is ill prepared. Because this right here, when you, and I hate to say it because we're all humans. You kick me out the room after I done watched you try not to let these people up. And you don't even want me to know that man that you told them how to go in, how to collect, to put on gloves. Then who told you that? Who told you that? Who told you that? Dance mom better stick to pirouettes and plies, because at this point, and he had to tell the Titans that he had police interaction. He did not hide that. He did not hide that. The crying dance mom. I don't know why you would lie about your child being, but we just live in that day and time. I don't know why she gonna lie about him being a police officer. That's something we can verify. She was better off saying that he was a general manager of Radio Shack, Toys R Us, or a pilot for Spirit Airlines at this point. We are on an impromptu break because apparently the state was holding out hope that the judge would not let any of these experts testify without reports. And so since Dr. Melissa was going to give them her notes, and the judge ordered for them to be copied and given to the state, he also was proactive in saying, if any other of your experts have any kind of notes, let's go ahead and give them to the state as well. What sort of cop? A fake cop? Fake cop? No cop at all. And we asked that. What kind of cop would tell you to go into a scene like that? What kind of cop would advise you to do that? A fake one. If you sitting at home watching cops all day, I guess shit may run together on you. You might think you actually a cop, or maybe you thought citizens arrest it went into search warrants. I don't. Y'all had 2 years to all get the lie together and some evidence. And baby, if this state, not the state, if the defense has that post of those girls being connected, that's the other thing, because the defense did bring up in openings that these girls were connected from Arkansas. Apple, Najee, all of them are connected. I hope they don't leave that as a loose end, because that would be a horrible end to leave loose after Apple came in. Now, I'm not going to lie, I wasn't as affected by it on Saturday, and I'm glad I wasn't, because I didn't think Apple's testimony was everything that everybody made it to be. I do think it could cause in at least a juror's mind that, hey, this is in his wheelhouse. He makes babies and then tries to figure out how to get somebody to delete the baby. So maybe this time this person wouldn't make a decision. But on the flip side, Apple chose to not have her baby, and he was fine with that. And she said, according to Apple, he wanted that baby, which completely contradicts how she says he acted about every other baby thereafter. But then I didn't like that Xavier's story was told without Xavier, right? If I've done something or experienced something where I had to make a decision with my body, fuck you. You don't get to go tell my story because you want to be in like Flynn with Dance Mom and them. I don't like that she was able to tell Xavier's story. Xavier should have been able to tell her own story if Xavier wanted to tell it. Who knows if Xavier ever told that story? Who knows if Xavier ever mentioned that story? Who knows if Xavier ever told her parents what happened to her in college? Who knows if Xavier wanted that out there? That is so effed up that she went and told Xavier's story. They should have had Xavier come, period. I don't like that. I don't like that. And then you go up there with the narrative, oh, he wanted my baby. I didn't want it. But their babies, he didn't want it. So why you the only one that didn't get a threat of deletion? It just really feels like you're giving that narrative in your head that you were the one. Which also can come, I'm speculating, with that delusion that happens when fresh meat hits the yard. I'm confused how Apple gets to testify to things her and Blaise talked about, but the psychiatrist can't. They didn't want that woman to say anything, and that's also why they didn't do a redirect, because they didn't want her to say anything. They know that boy was fucked up. And you can tell that he was messed up, but even worse than being messed up behind what happened in front of him, I think he was more messed up about how to feel about it. Speculation, pure speculation, okay, on my part. But I do believe that Blaise could have possibly been more effed up about trying to figure out how to feel about it versus how he should feel about it. And how he actually feels about it versus how he should feel about it. That would be kind of effed up. And the only reason why I say that I'm speculating in that way, again, I don't know if this man is innocent, but the only way I'm saying I don't understand how we know that he was going through something mentally, because he kept changing the degree of their relationship. As the situation, in my opinion, as the situation got more severe, his relationship with her grew more depth. Now, if he did not do it, it seems like it would be very weird for a person, not very weird, but it seems like a mental struggle for a person to start with somebody that they don't know, having a baby with, trying to get to know them. And think about it. When it starts with when it starts with allergic reaction, he's at friend, right? Then when allergic reaction escalates to cardiac arrest, it's girlfriend. But when Jade's got tubes in her, it's the mother of his child. He escalated, from what we heard, with her, with elevation of her situation. So to be at mother of my child, then go home and sleep on it and wake up, and it's like, I really don't know this person, but damn, that's my child's mother. Like, it's a mental mind fuck. Perfect words, Laura, or as you were this weekend, Miss Wawa. So again, we don't know if anybody is innocent at all, and I would never venture to say somebody is innocent. You don't know. Real, I don't know about taking a stand. I don't know about taking a stand. I'm always leery when a defendant puts on a case. I'm not mad at this lineup of witnesses though, because it obviously has rattled the cage of the state. It has ruffled the state's feathers. That is not going unnoticed, but I always get nervous when they even put on a defense, because I'm like, well, why do you need to defend yourself? But that's his right. And if this is the lineup, it's not people coming and saying my baby would never. I hate when I see parents on the stand. I do, unless it's a character witness. I hate to see parents on the stand, because don't put me on the stand for mine. I might correct my kid in private, but you ain't down. Don't trust me. Don't trust me. I would expect a parent to say everything they said with the absolute full heart of love they have for their kid. So I think, and then even if the parent is telling the truth, a person in the jury may take it with a grain of salt, because they may expect a parent to lie, or they may expect a parent to try to protect their child in the best way they think they know how. So I never feel like parents tilt the scales in any way, shape, or form. And why waste the witness? Because you're going to get up there and say what I already know. You love your child. This ain't the child you know. This ain't the child you raised. Your child would never. And all those things are true. Our parents don't know us the way we really are. Dear God, thank God there were no camera phone. Well, there was a camera phone, but ain't nobody have it but me and one other person my senior year. So thank God there's no footage. But my mom, we went to school and cussed like sailors, and then stopped singing the song when our mamas was around. Your parents don't know you the way the rest of the world knows you. Okay. If you got the comments, you pretty much got it. We really are just waiting for them to get. It sounds like the state, LaPanda. It sounds like the state really thought that the judge was going to throw out every single expert that the defense had, because if they didn't have a report. Judge said he ain't say it like that. If there is a report, it should be shared. If they don't have a report, then he called it tactical. They don't have one. That's it. Kathy, you were so right, because I told you I was married, and I still told Pop I didn't know how Dallas happened. At not one point in all 34, 35 years of my time on this earth with my Pop did I ever admit a thing about my Hakuna Matata, except I was going to the doctor every year. I'm not discussing my Hakuna Matata with my dangle. I don't know how that happened. Let me tell you something. It could have been my mama, my Pop, and Jesus Christ of Nazareth sitting right there in my face, and I would look at my Pop and say, I don't know what Jesus talking about, how he get here. Wasn't Joseph. I'm just saying it's happened before. I'm not telling my pop out and bust it open and lay those spread it wide for nobody. I'm not even saying it now in case you hear me in heaven. I'm not saying it. I don't know how them kids got here. They here. Period. They don't want to hear. Now, Pop was a little different though. He would say certain things, but I'm not. I wouldn't admit it. Because when I called Pop, I had about 6 pregnancy tests. Like, I'm going to go to the doctor Monday to confirm. Pop said, look like it's confirmed, little girl. No. He said, well, you got a husband. How you think it happened? I don't know. We're going to talk to the doctor on Monday. Thank you. Because I don't know what that was about. We're going to talk to the doctor on Monday, and that's just what it was. Pop was pretty no nonsense. I still wasn't going to tell him. I wasn't about to admit it. Tiffany ain't admitted it was out here. I wasn't about to start. Tiffany said, Pop, I don't know what happened. He did wait for Denver. He was excited. I was literally paying a phone bill so he can ask me where Dallas was for a whole year. Are they on break? Murdaugh in his hearing. I can't believe we going back up in this thing for Murdaugh. I can't believe it. If y'all didn't see my video, they've turned, I got to double check, but I believe they've turned the sentencing hearing for Jason Meade in regards to him being found guilty of reckless harming of Casey Goodson Jr. He was supposed to be sentenced for that tomorrow. However, his defense counsel has asked if that can be turned into a bond hearing because he is actually I have to go on Franklin County's website. They asked for a bond hearing because it sounds like the state's getting ready to go back after his ass for first degree. I don't know why he would want to get out on bond because he's been out on bond ever since. Well, it was a year before he was even charged with the unaliving of Casey. 364 days before he was even charged. He spent maybe 4 hours in jail at that point. So he would get no credit for time served from all this time he's went from 2020. So yes, they've turned the hearing scheduled for tomorrow into a bond hearing. So he won't be sentenced. They asked for it to be a bond hearing for him to be able to get back out to aid in his defense. While awaiting this potential third unaliving trial. Why does that name sound familiar? Terrion Arnold. I'm going to have to look that up. The football, right? Oh, he up there in Hillsboro. Oh, they going after him about bond too, huh? Lured 3 men to an apartment where they was whipped with a popper, robbed, and held at that kind of point. He orchestrated the assault, lured them to the apartment, and this was in retaliation to them stealing somewhere between $200,000 and $250,000 in property from his rented Airbnb. I'd have whooped him. I don't condone violence. Hypothetically, I'm not saying it's okay to put your hands on people, but $250,000 worth of property can be replaced. But I'm not saying I wouldn't be pissed. Not okay to break the law. I'm just saying I'd probably be pissed too. It was the wrong people. You can't be so pissed that you're blind. Terrion Arnold. He was a cornerback for the Detroit Lions. That's part of it. You are a civilian. Call the law. But I also feel like it's a fine line between that, because I still don't understand. I understand, but I still don't understand, because Gucci Mane was known for jacking folks in the studio for a very long time. He was known for being a jack boy. Didn't he jack French Montana and had him up in the hotel crying? But then somebody jack you and you call the law. I thought that was the craziest shit. However, I do understand, in order to make an insurance claim, you got to have a police report, and you ain't just taking my shit. Now, it's goofy to take his wedding ring anyway. Like, people don't know his jewelry, because his jewelry is very distinctive, and he goes a lot of places with it on. So you wouldn't be able to just walk around with that ring and not know, like, nobody else. I mean, it's not a ring you walk in a jewelry store and they have multiples in different sizes. Like, it's probably pretty custom. Gucci, another story. I get it. You get to a point where you can't be acting like that. I get it. And he was in 2 different tax brackets when he had those 2 different reactions. But it always, just because we've heard all the interviews and the confirmations of Gucci, it cracks me up. But Gucci is a different person. It also is very crazy to me and contradictory to me that when Gucci was that person and he was off his rocker and acting crazy, and obviously running around with, now we know, undiagnosed mental issues, everybody thought he was cool. When he get himself together, lose some weight, start eating right, get on his medication, and start talking to a doctor, everybody called him a clone. That's fucked up. That's fucked up. Printing the contract, see? There's a lot. Life is just contradictory, okay? Life is just contra-damn-dictory. ODB was a different sort. He was a different breed. ODB was a breed in himself. He truly was. It just damn different. Just damn different. Oh, okay. Just like the watch in Atlanta, if it's one of a kind, you can steal it, but she can't be seen with it. Oh, God. What about Trick Daddy Dollars? I watched a little of the football player trial, and it's a lot of hearsay, nothing solid on him, in my opinion. Really? I might have to go start it. Give me something to watch, because it looked like we about 30-40%, getting close to being 40% done with this particular testimony, and it's only 11 a.m. I mean, his case, and it's only 11 a.m. Depending on how long it's going to take them to finish going through these experts' notes. So we could be actually finished with Blaise's case today, or worst case in the morning, which means they will have their charge conference and then go straight into closings and deliberation, maybe tomorrow or Wednesday. And the thing about that, are they going to go into deliberations on Wednesday? Because then I wouldn't want the jury to actually feel rushed, because there's going to be no court Friday, right? At least Friday. Well, Hannah, I don't think they proved anything either. I don't think they proved much of anything, but maybe it's just me. I would want them to put Blaise at least with the unaliving weapon around it, near it, in proximity of it. But the judge saying maybe that don't matter. Maybe it's just whether or not the jury believes Najea's version of Jade's last words. Now, I do think in a world where if he gets convicted, because we never know what a jury is going to do or what they see or what they believe. If he gets convicted, does it stand? Because what evidence is it standing on? Evidence that was clearly tussled and toiled with, collected by a ragtag team of meddling kids. They didn't find anything on his phone. Nay, they didn't go into it, but I believe they didn't go into it because there's nothing there. They had 11 devices of his and his entire iCloud return, which we know clearly went back to at least 2018. We know at least 2018 it went back to, because they claimed that they confirmed messages between him and Apple in 2018, the ex-girlfriend. So the only thing they ever tried to enter was how many Google searches he had, but they never went into what those Google searches were, and they got shut down by the judge by trying to go into how many. We never got into any specific Google searches, how to delete, when to delete, options for deletion, looking up deletion clinics, nothing like that we would expect to see if you're trying to help your girlfriend have the information to make an informed decision, or at least see your side of the argument. You look up resources. What do I think happened? I hate to say this, but I don't know what happened. And now I kept saying, I don't think Jade did it to herself. I do not think Jade did it to herself. Trigger warning. I'm sorry, guys. Now that both of the state's experts have stated that the dosage or the amount that she would have ingested, because I was thinking this astronomical number, it had to be this astronomical amount, but they're saying that it could have been a little tiny small concentrated amount, which that could be self-administered. I'm wondering, did she get something bad? Did she touch something bad? Because trace amounts of Fenty is also on the blanket where there is no stain. Now, that could be because Goof Troop and the Goofies rubbed it up against something in that trunk, or their hands or their gloves. But either way, it creates doubt. I think I cannot deny the fact that nobody was in there with her during that time, most of that time period, but him. But I also feel like he wasn't the only last person to see her in a healthy state. I have a feeling. I'll say this. I have the same feeling with Jade that I had with John O'Keefe, and that is that I don't know what happened, but whatever happened to Jade, I do not believe it's as serious as this cover up. It's serious because she's no longer with us, but I feel like the cover up is making this worse than whatever the fuck it was. I'm like, even if there was, like, let's say she did have a little stash in the house, even taking that out to make sure that he is convicted, even if he did it, makes this look crazy. Them going into that scene and contaminating it makes it crazy. I think the cover up is worse than the crime. I think what happened to Jade probably could have been very explainable. Like, it could have been explained, but the constant going in there, lying about it, covering up, turns this into making this some diabolical scheme that just causes all these conspiracies and all this stuff. I don't think you think Najee wanted to take out Blaise and put it in the wrong cup. Could be. But the other thing too, Hannah, and I was saying that too, and you don't want to ever think that about your loved one, but usually when somebody has a little bit of an issue, they're not going to just come out and tell everybody for them to be judged. She was already being judged by her best friend in the text messages when she said, and you've been drinking? So if I've been drinking, if I'm still partaking, am I going to tell you? So we don't know. I don't feel like we will ever knows. What is wrong with me? I don't feel like we would ever know what happened to Jade. I feel like the fact that the family has done so much, tried to, and then lied about what they did and keep lying about what they did is making this worse than what it is. It's taking so much. If Blaise did it, it's taking so much attention off of Blaise. It's like they're manufacturing doubt for Blaise to use. The fact that she said, "What did you do?" or "Give me to Najee," says they was on something previously. Yeah. It just, the lies cause so much doubt that you start to look at wondering if Blaise is innocent, and that's a question you'll never be able to answer. Not guilty is the only thing we can look into, and that's based on whether or not the state makes their burden. But this family and friends have lied and denied and covered up so much that you almost start to think you can guess if Blaise is innocent, and that's delusional. That's delusional to think that but it's that bad, the amount of lies. The other thing I like is there's no statute of limitations on unaliving. I can understand you don't want to wait 5 years, 10 years, 15 years, 20 years, 30 years. Hell, we about to have Tupac's trial after 30 years, right? 30 some years. I would just say I would rather you wait this long like Tupac and get it right than try to hurry up and do it and get it wrong, because you only get one shot at it. And if Blaise is found not guilty, but he truly is not innocent, he's done. You can't never go back at him again. That should be scarier to F it up the first time than anything else. Users hide their habits very well. Hannah, I can. Well, y'all know the story I went through with my that we went through with my sister's ex-husband. That went on about a year before we figured it out. And my nosy ass figured it out. And I still was about the second or third person from actually figuring it out. I was not first. So I just feel like whatever happened to Jade could have been explained, and I would have rather seen people get up here and say, I fucked up. I fucked this up. I should have never went in there. My emotions were high. I knew that he did this. I know what I heard on that phone, and I went in that and I went in that house. Judge me. Judge me. I'd rather you convict me for tampering with evidence than to have me up here playing games like I didn't touch anything. Yeah. For my friend, I wouldn't have wanted to go back and forth with and look like I got an attitude with the defense. I can understand having an attitude with them because if my loved one is gone, how dare you fucking defend this monster? I'm gonna have an attitude, but I'm not gonna lie and give you something to use for the monster. I'm not helping you.
The state ready?
Yes, Judge, if you were just, honestly, to expedite the process, we are no longer asking for the jury out. We have our toxicologist that's on the link. And we won't, if your honor's going to allow the witness, we won't object.
Okay. I mean, if you want to be heard on your qualifications and all, then I can do that.
Not as a jury.
Okay. And then if Dr. Minton is to be recalled,
I don't know. I haven't heard anything.
Medical student, access to different substances, and Tam, I'm gonna go one step further, access to labs.
what are you?
Because remember, the state is kind of pushing the narrative that this sugar, this adult sugar, was liquefied. Who would know how to do that? A lab?
She would be, as you said, offered as rebuttal. Raise your right hand, we'll just bring the jury down.
We just got handed, are these more notes for her?
Hey, shut the door there. Did you give them earlier when we were in here all of your notes?
That I had with me? Yes.
I have 4 pages that she handed us.
What is all of this?
I just got handed this.
Bring what you asked us to print the notes.
For this witness?
Yes,
I thought she provided it.
you wanted emails, so by.
No, I didn't want emails.
You
I
asked,
asked her for notes.
she gave her notes,
What are these?
my email.
These are
I
not,
didn't ask for emails.
these are not emails. I just got a whole stack of notes.
What is all this stuff?
That was you had asked earlier if I had sent her work product of what I was doing as I was reviewing the data, and that's what that is. That's what I sent to her a long time ago prior to preparing for testimony. This was my analysis of going through the data.
So she did give you notes.
Sounds like a report.
Let me see what you have, I don't know what you have.
That's
I don't know
not,
it's what you emailed them and somebody printed these out.
it's not a report. There's not an opinion in it.
Your Honor, the state renewed our
This is
objection to this witness.
This is the exact same thing that is a snip of the litigation package. It's all it is. And
Okay?
then
You determine whether most of that is from your witness's litigation package?
There's only,
got
I
it up
think,
yet?
the last 3 pages of this.
He is, or you about to wake him up?
And then what's the other stuff?
You want to let him sleep for a little bit?
May I explain to her what she's looking at?
Okay, go ahead.
I'm asking counsel.
If you look, all of this are snippets of the litigation package.
Is all of this snippets from the litigation package?
All of it is derived from the litigation.
And then
What do you
there are
mean
notes
derived
on
from?
top of it.
It's notes on top of it of what I was
From
seeing
who?
from me as I was
Why didn't you
looking.
give us that earlier?
I didn't have it, sir. I don't have
See,
it.
this is what hide the balls off. You know, I got a jury back here, yes, I'll direct myself to you, that's thinking I'm an idiot because of this trial. the procedure, the logistics, and they're back there wondering what in the heck we're doing. That's why, the intent of Rule 16 is not hide things.
I'm getting the notes in the same manner that they gave
Why
them
did
to
they
me
give
with
them?
Dr.
I'm not worried about how they
Nichols.
gave them to you. I'm dealing with how you gave them to them.
Well,
Do you think, Mr. Brand, Rule 16 doesn't include providing these notes pre-trial?
no, he did, and so.
No, he didn't. Y'all didn't. I'm asking him, do you think Rule 16 would include when it says copy, photographs, documents, reports, and provide the other side, if you've requested discovery? Did that include this stuff?
No,
How so?
because I think this probably changed under 26.2.
But they're reports from what you're proposing to be an expert.
I don't think that's a report. I think it's her working notes as she's reviewing the material, which could be Jake's material, but is not a Rule 16 report.
See, that's the problem with efficiency, which I hate inefficiency.
I appreciate it.
So, do you need additional time now?
Yes, I would like for my expert to be able to have this. I just got handed it as she was
Can you email that to your expert?
completely disorganized. Judge, I submit that what she has provided is a report that she provided to the defense, and she just said it was a while ago, and the defense did not provide it. We filed a motion to exclude and asked your honor to exclude any witnesses that had not provided us with a report pre-trial.
They're saying that's not a report.
I mean, do we need to have a jury out to determine if it is? If it is a report, is your honor gonna exclude it?
Sure.
Then I would ask the witness, there be a proffer to the court for the court to make a
That
determination.
can copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions thereof, if the item is in the defendant's custody and intended to be introduced as evidence in their case in chief.
This is not being introduced in our case in chief.
That makes no sense.
Well, it's not being introduced for our case in chief.
So you want to orally ask her all about it and then just. I'm not moving to
The same
introduce.
manner that General Norman did.
I'm not dealing with that. I'm dealing with, have you complied with Rule 16?
Yes, I have.
So you're not gonna ask this witness to introduce anything?
No, I'm not.
So what do you want, General Norman?
Well, honestly, I guess maybe my paperwork to go copy it and send it to our expert.
I thought you got an email with that in it.
I haven't even had a chance to look at it, but what the little I
Jesus.
looked at, it looks like she typed.
What do y'all think about that?
It's not a report.
Where is that?
What do y'all think about this? Notes or report? Let me know. Y'all think this is notes or do you think it's a report?
Where's the copy I gave you?
Here it is.
What page in that are you thinking is a report?
There's
Oh, you're
one
awake?
that has
Good morning.
like 7 or 8 pages and a couple of pages of litigation packet in the back.
Is the robot
I'm
vacuum?
worried about the litigation.
I'm not either, it's everything that precedes it.
Will look like, I don't.
I'm just thinking of this not in a lawyer way, but a very elementary way. And there was no way that I was able to take all of my notes and just hand them in and call it a report for a grade for any teacher or professor. I was expected to take that and turn it into a report. It would typically have to be signed. I think it's all of her notes. And I'm only going by, I've written a few reports in my day. And at no point in time, I wish I could have just thrown all my notes and resources together and said, "Here you go, make some sense of it." I swear it's in there, but I don't think I was ever able to do that.
Telling you what she's finding in the medical record.
He's been awake. He came and woke you up. You late to the
She
party,
is
Johnny. Come lately.
regurgitating what is in medical.
You give me a hug
records.
this
It's
morning.
not an opinion. She's not a doctor, so there she can't get an opinion on a medical record.
You, Johnny.
Saying here,
And neither are we planning on introducing it.
Good morning. Yes, baby.
75, instrument had an error, incorrect vial, not on our case. What's she reporting to you?
What's in the litigation package? That is not her opinion, that is directly taken from the litigation package.
I wouldn't be backing down either. I couldn't turn this in anywhere else as a report. You wouldn't be able to turn it into the judge and call it a motion. You can't turn it in and say it's a report.
I think the witness should be excluded.
Okay, other than that, what do you want to do?
I would ask the court to give us 5 minutes so I can at least have the paperwork in front of me before she starts
Did
testifying.
you get this document through an email?
I don't know. She handed me documents, she emailed me documents. I'm
It
asking
was
that
an
all,
email to the court.
I asked
Were you
all
not
of it
in
be
on it?
printed. I'm saying I don't think they're the same things. What she handed us and what she emailed us, they are printing it right now.
The emails that I sent over are nothing but logistics. I sent them over because they're emails.
Sent them to who?
To Joe.
No, I'm not talking about emails in the past. I'm talking about, did you email this packet to the state?
I don't know.
Yes, Your Honor, I believe that the packet that you're holding is included in the email to the state that has
Did you get this
several
by email?
Word documents.
I received an email with 7 attachments that say summary of lit package, which sounds like a report. If she is not introducing anything, then I
Do you
request,
want to forward this to your
yes.
Dr. Mid, can you do that?
I have forwarded the email. I'm asking that the printed documents, which don't appear to be exactly.
So it was given to you?
We can send that, and that's happening right now.
How did I get this if it's not included in an email?
I'm saying she handed us documents and the emails look like there's additional things.
Who handed you documents?
They did, right when she was walking out
Was
to the.
this
Say her name. Don't
sent
point at
to
people.
To the state as an email?
Yes.
Yes.
Do you have that?
Yes, Judge, I received it a few
Okay,
minutes
can
ago.
you forward that to your expert?
I did.
Okay. All right, so do you need additional time?
I would like to have a copy, but I guess.
Oh, okay, give that to the state.
So when she gave you the copy, you had a knee-jerk reaction to say, "Hey, wait a minute, you said give me notes." She said she didn't have any notes. Now these notes look like a report, so therefore go back to my original request
Do you
idea, hope,
want additional time?
which hope is a bad
All right, let the
strategy.
jury step
But
in.
hope that you was going to kick this out because none of them have reports. Now you see all the books and all the things as resources, and you want to call that a report, and they don't let you do that either because you can't slap some notes together and call it a motion either. So then you get it, and come to find out the whole time you've had all 7 attachments that make up this set of notes. Ma'am, this better not be the case because you didn't held us up for a good 20, 30 minutes about whether or not this expert should be able to testify when the whole time you had the notes. These better be different notes. I mean, I hope not for the defense's sake, because that would look real crazy, like they're hiding the ball. But you just sat up here and let this judge accuse the defense of hiding the ball when you really actually had it.
Testifying to anything related to any report that was not introduced as evidence in the state's case in chief. She cannot introduce NMS reports that have not been introduced.
Okay,
And so,
these 2 binders,
no, those are the medical records.
okay.
So NMS did more testing than what was introduced in our case in chief, and I'm objecting to her testifying to any reports that were not testified to by Dr. Mitten and entered as evidence because it's irrelevant to this proceeding to talk about other tests
that were not presented to the jury.
Okay. Do you agree with that, Ms. Hollis?
I do, because we're only
Okay.
talking about the two.
Good, then we don't have a problem.
So you're just trying to come up with a way to exclude or limit this expert. Because whoever said that they were getting ready to testify about a report that was never introduced in your case to see? The bigger question would be, why do you have access to all these reports when you're not using them?
As far as the
Look.
testimony you're about to give to be the truth, and
Yes.
Her and she and pointing. You know that woman's name.
All right. Okay,
Yeah, I saw it. I was watching it. I got Megan's feed up.
Good afternoon, Dr. Gary. How are you?
Good, how are you?
I'm good, thank you. Could you please state and spell your name for the record, please?
Dr. Melissa Jagger, Melissa Giguere.
And how are you employed?
I am currently an independent contractor for forensics toxicology and science.
And where are you in terms of company that you work for? Who do you work for?
I currently work for a company that I own. It's MG Forensic Consulting.
And how long have you been a toxicologist?
I started doing toxicology in 2014.
And where did you go to school?
I received my Bachelor of Science at the University of North Texas, and I also received an Industrial Master's from the University of North Texas in chemistry. An Industrial Master's is different than a regular Master's because I did not have to do a thesis. I had to be working in the field and had to write my paper in regards to what I was finding and doing the lab work in the field. And then in 2023, I graduated from Oklahoma State University with a Doctor of Forensic Sciences with an emphasis in toxicology. It is not a PhD, it's a professional doctorate. The difference between a PhD and my doctorate is I didn't have to write a dissertation. I had to be employed in the laboratory, and all of my papers were based on data that I produced while working in a laboratory.
She said her degree is based on data, not making it up.
How many,
Not making up a thesis.
I would say, how long would you say that you worked directly in a toxicology laboratory?
Just over 10 years.
And have you been peer reviewed with your work? And have you also peer reviewed others and their work?
Are you referring to peer reviewed and just releasing my data and someone reviewing my work prior for release?
Yes.
Yes, I've done both ways.
At this time, we would tender Dr. Jagari as an expert in laboratory toxicology.
any questions on that request from the state? All right, ladies and gentlemen, the jury would still have to give an expert opinion in her field. Like I told you before, you can place such weight on it as you choose.
And do you have a curriculum vitae in regards to your training, experience, and education?
Yes, I do.
At this time, Your Honor, I would tender Dr. Jagari's CV.
All right. You want her to see it?
No, but just tender.
Okay, just give it to the clerk for 15 minutes.
Dr. Jagari, have you had the opportunity to work in labs that are accredited by the ANAB?
Yes, I have. I did my full 10 years working with an ISO ANAB accredited laboratory.
And what exactly is ANAB?
So ISO 17025 is it's an international standard that people who do qualitative, quantitative results have to follow this standard. It is if you look up pharmaceutical companies, petroleum companies, they follow it as well. So then you have ANAB, which is a subsidiary more for forensics that you have to follow. And so it gives a little more guidelines to be more for science versus petroleum or some other company that could have ISO. But then it goes a little further, it goes into ASB, which is an American Standards Board, and they produce guidelines and standards specifically for forensic toxicology. So you have a blanket overview and then you kind of narrow down into a funnel from there.
And can you tell us some of the things that are required in order to be accredited, such as chain of custody, such as keeping things stored at proper temperatures and things of that nature?
Sure. So the accreditation is very, the ANAB standard itself is very bottom line. It's very minimum, and it says you have to maintain a chain of custody. You have to monitor your refrigerators, and it should be kept between this temperature to this temperature. But you get those more finite details in the American Standards Board standards, those ASB standards. ANAB is more of a general. It's you have to do this, but you should try and go better. It's the bottom line of what it is. And so you have to maintain chain of custody. You have to document all kinds of everything in a forensic laboratory. You have to, the bench notes that as you're working through a case and you take a bench note, you write down it's oily or it smelled funny or whatever, that has to be maintained with the case file as well. It also goes through guidelines about who's allowed to work on it based on credentials. It goes through who has access to certain areas. It restricts that. It doesn't restrict it, let me clarify that. It dictates how you should document who has access. It's more of a documentation aspect from ANAB versus the recipe on how to do things.
And why is that important?
Forensics is the way I look at it, has three pillars. You have integrity, you have chain of custody, and then you have unbiased opinions. And you have that as a three pole and a stool. If you lose one of those, then you kind of wobble and you kind of can lose the reliability of the forensic analysis that you have. And so those guidelines between ASB, ANAB, and ISO all help to make sure that that stool is good and stable and it can be reliable and accurate at the end of the day.
So I want to draw your attention to the NMS lab report number 231-26889. Are you familiar with that toxicology report?
Yes, ma'am.
Do you have a copy of that report with you?
Yes, ma'am.
How many reports were issued under that work order?
I just have the one that was originally provided to defense, that was dated 5/16 of 2023.
And have you recently been made aware that there was a new report issued on June the 10th of 2026 in regards to litigation packet 231-26889?
Yes, you informed me of that.
I want to talk to you about whether or not when you did your analysis, well, let me ask you this first. Did you do an analysis of this particular toxicology report?
I wouldn't call it an analysis in the sense of science. That's doing actual chemical extractions. I did do a review of the data.
Okay.
Sorry.
Excuse me. I need to get with your terms. So tell me, what, if anything, did you learn after reviewing the data in regards to work order 231-26889?
So when I first reviewed it, what first caught my eye was, we can see at the bottom it says specimens received, so that's what I go to look at. Typically, if you're looking at anything for blood.
Sorry.
Oh.
It's not working. Don't worry, I can use this. My computer doesn't like that. Can I switch? We're gonna end up having a problem with it, so don't worry about it.
My witness is not in the feed, it keeps hanging up and she's not able to view what's happening.
Or your witness keep hanging up because she fears that this witness has her shit together. Again, this is probably going to come down to a battle of the experts in this particular light as far as this toxicology report. But if somebody who also reviewed the data has all these notes that she shared, all these notes, and those are just her working notes, versus Miss Ma'am who just re-signed it in an hour with no note, somebody could take that into consideration if that's indeed what these
You
notes
wanna go out and call her and see where she might be or relocate?
And if the Zoom is not working, Keisha, why didn't she jump over to a stream? You could have hopped on Long Crime Court TV with a couple folks that outside of this, local places that are streaming this. It's being streamed in a lot of different places. She could have simply just jumped and said, hey, I had to jump into Court TV stream because that Zoom link is not working.
Hunter, is there any way that Dr. Midday could just have an audio line? I mean, how do you do it on the cell phone?
Ladies and gentlemen of the jury, if you'll step back down the hall.
This is the documentation. It's always something. Dang, come on, man. You trying to make them lose momentum.
I don't know of any way to do a Zoom link and do additionally what we're talking about doing in this trial. Is she somewhere that she could relocate or get better internet service?
She said she tried it on Wi-Fi and also her cell phone. She was in the car driving and drove to a location so that she could do this. She said if she could just be on a phone line so she can hear what is said, that would be sufficient. Is that a possibility?
I don't know how well she'll be able to hear, but we can call her from that phone right there. As long as she's not speaking.
She wouldn't be speaking.
You want to come punch in her number? Hit speaker.
believe this is Carrie.
Dr. Smith, this is Jean Norman. Can you hear me?
I can, yes.
So I have you on the phone report.
Okay.
Can we ask the witness to say something to see if she can hear?
Can you hear me, doctor?
Yes, I can. It's a little, difficult, but, I can hear you.
Exactly.
Can you
So get
turn
on
the
extreme.
volume up on all the mics? All right, can you state, can you state your name, please, ma'am, for the record?
Melissa Jagger.
You'll have to speak up into that mic.
Melissa Jagger.
Can you hear that?
Yes, that's much better. Thank you.
All right, bring the jury back then.
Judge, Dr. Mendon couldn't hear the report number. Can we just let her know that we're talking about 2312688?
231.
Why are you trying to commandeer their direct? Your witness should have been there instead of you hoping they wouldn't get the dang on testify. Everybody can watch on YouTube but her. Come on. Never heard of it before. Dr. Missing from yesterday. Remember we started yesterday with her cross? She's the one that just re-reviewed or did an overview of the report, and the corrected report is just a change of to her signature. Her. How do I know who's on the other end of that phone? There you go.
All right. Go ahead, Ms. Howard.
Dr. Jageri, we were talking about litigation packet 231, toxicology order, 231-26889 from NMS. Can you tell the jury what sample of specimen is this referring to?
You'll have to speak into the mic.
It's referring to the clear plastic top tube with 1.75 mils that was collected on 2/25/23 at 22:31 or 10:31 p.m. labeled hospital blood. And it also includes a clear top plastic tube, 8 grams, collected on 3/7/2023 at 13:34 or 1:34 of liver tissue.
Now, we see there on this report that number 1 is a clear plastic tube, which is self-explanatory. But could you tell the jury what is ID 003, homogeneous container?
So as you heard from Dr. Mithun, that's where you take it and you blend it essentially and make it so you can, in analytical chemistry, you have a thing, it's called an Eppendorf pipette, and you have to draw up a specific certain amount for the test to be accurate based on validation. And so you have to make it to where you're able to draw a liquid into this little tip to be able to start the extraction. So the laboratory took, I don't know how much, usually it's documented, but you take a portion of that, you weigh it on an analytical balance, and then you mix it, in my experience, we've mixed it with water, and we put it through a blender, better way to think of it, and you hit go and it blends up the tissue to make it to where it is more pipettable for the equipment.
And we see that on item 2 and 3,
Oh my
it
God.
notates liver tissue. Do you know whose liver that this report is referring to?
I do not, because the labeled as number is the same. So I would think that I interpreted this when I was first reviewing that the liver was from the same person with the hospital blood.
And whose hospital blood does that belong to?
Based on the review of the medical record, that it was tied to a Jade Benning.
Have you since learned who the liver tissue belongs to?
Yes, it was discussed that it was belonging to the fetus of Ms. Benning.
Have you, well, in preparation for litigation, is there something that NMS will provide to attorneys if the attorney requests that?
It's called the NMS litigation packet. You've heard about talking about litigation packets.
The answer would be either yes or no. Did you get that?
Yes.
And can you tell the jury exactly what a litigation packet is?
Sure. So a litigation packet is a copy of the report, followed by a copy of their receiving data, where they start their chain of custody. It also includes the summary of who would have touched the sample along the way. It also includes the, if there's a disposal, there's a communication log, anytime that there's a communication regarding to that particular case. Sometimes there's also emails that are included in it that are not in the communication log, just within their own departments. Also included in that are all the testing that was completed for that case. So in this case, I believe it was around 1,900 pages to review. You have every test that was ran on it. You have all of their standards, which are the calibrators, which allow you to put a quantitation number to something. It also includes the quality controls, and it includes this case specifics data.
And did you have an opportunity to review the litigation packet for toxicology report 231226889?
I did.
What, if anything, did you find as a result of reviewing that report?
Looking at the, and I don't have it up here, I didn't bring all of it, but the request was signed to be relinquished from the medical examiner's office on 3/31. It was received at NMS, I believe, on 4/4. With any kind of blood sample or even just tissue, anything that's biological, it needs to stay refrigerated. For multiple reasons. It helps to slow down any kind of growth or breakdowns, preferably to be frozen, but it helps to reduce that. And then looking at when it left the medical examiner's office, I presume it arrived with the body. Part of my past experience is I did medical examiner work, and we would get antemortem tubes with our postmortem samples to look at and compare. And when we would get that, they would be multiple tubes to choose from. And so I don't know if there were multiple tubes that in this case, and this is the one that they chose. But it was collected on 2/25, and it doesn't, and as far as I can tell, arrived to the medical examiner until 3/7. So I don't know how it was stored, who had access to the sample. It was collected for medical purposes. So I don't know what was done at the hospital for testing, opening, who had access to it there, how much blood was removed, did they spin it down at all? Anything that could have happened to that tube prior to it arriving at the medical examiner's office.
Are you stating that you found that there was an issue with the chain of custody with this particular sample?
Yes. And the medical records also state that they couldn't identify a chain of custody, which is why they contacted the PD to have the PD come draw their sample to establish a chain of custody. And that was after the sample.
So did you ever find in your review of any of the materials, anything that could establish a chain of custody that would be sufficient, in your opinion, in regards to the ANAB standards?
The laboratory maintained a chain of custody, and that's where the chain of custody started.
What about previous to the time before it got to the laboratory or arrived there?
I don't believe I've had any documentation for that.
Was there anything else that you noticed about this laboratory report that you found issue with?
I notated that there was no seals on the tubes when they arrived at NMS. There was no evidence tape over it. There was nothing to seal it. Not saying it was open and spilling everywhere. I'm not saying that. The sample would have been closed because there was notation of no spillage. But there was nothing over top of the tube and a date and an initial to make sure that it hadn't been tampered with or had anyone had access to it prior to it arriving to the laboratory.
Is that something that ANAB requires of an accredited laboratory?
No, it doesn't require it to be that. It's just required that they document how it was received.
What do you find is best practice when you're dealing with these types of forensic toxicology tests, especially in criminal cases?
In my experience, we've received our samples for forensic toxicology to be sealed, dated, and initialed by whoever collected it for the integrity of the sample.
And was that done here?
It was not.
What type of tubing was the blood or the vial of blood? What type of tubing was it packaged in?
It was in a clear plastic tube, which would have no preservatives. So if there was a dirty collection, meaning they didn't have the site clean and some bacteria got in, there's nothing to even slow down bacteria growth or bacteria formation. And there's also nothing to slow down or retard any of the degradation of any of the drugs that would have been present.
Are there, if you could educate the jury, and we've all had our blood taken before, are there different types of tubes that are utilized to preserve whatever the sample is, whether it's blood, urine, whatever that is? Are there different type of tubes for that purpose?
Yes, there's different color top tubes. Ones that I'm familiar with from working in the laboratory, we sell tiger top, we sell blue top, purple top, and those are all unique to the medical field of what they're looking for to test. So each of those have a different preservative in them depending on what the medical need is out of that sample. The most common one used in forensic toxicology is the gray top tube because it has potassium fluoride or potassium oxalate and sodium fluoride, and both of those help to slow down or retard the formation of bacteria, as well as help to preserve the blood specimen as best that it can.
Now, was this sample actually preserved with the proper tubing?
Not for forensic testing.
So did you find that as a result of the issues, well, let me ask you this, were there any other issues that you found with this particular vial of blood?
I think that those are the main ones that I found.
At some point, were you able to ascertain the levels of concentration for this particular vial of blood in terms of what it was looking for? What exactly was this test looking for in regards to this toxicology report, I should ask?
So it was looking for cocaine in the products, which is what it's listed as, which is the cocaine and the metabolites. And the blood was also looking for designer opioids, which are going to be looking for your more typical illicit fentanyls and illicit opioids. This did not look for the actual drug of fentanyl.
And so are you stating that where we see the testing designer opioids, that does not include fentanyl?
It does not.
Did you see anywhere in this particular report where it was asking for a fentanyl test?
I do not, and they also didn't order a general screen that you typically see with forensics post-mortem that we saw in the liver, which is a very broad looks for multiple substances. And I believe there was a note in there that it was a direct reflex for cocaine in the designer opioids because they were nervous about the volume of blood that they had left for testing. So they directed the sample instead of taking out of the normal flow of how a sample would have been received and processed.
And were there results as a result of the testing for this particular report? Did it yield any results?
It did.
And what results did it yield?
We have benzoylecgonine, which is the first major metabolite out of cocaine, and cocaine, which is the parent drug, and then ergonine methyl ester, which is a secondary metabolite out of the parent cocaine.
Was there anything else of consequence that resulted out of this blood as a result of the testing that was performed?
So the things that are reported are things that are above their, what they call the LOD, the lower limit of detection, or the LOQ, which is the lower limit of quantitation. I'm not sure, it was not provided their SOP or their validations for these methods, so I don't know if those are one and the same. Some laboratories, their LOD and LOQ are the same. Then what that means is that the instrument cannot look below that quantitation level or that limit of detection and be reliable. And so I don't know if that included that, but in my review of the data, I actually did find that there was some of the metabolites that were present that were just not above the reporting limit, so it wasn't reported, but there was presence of an indication of in the data.
And what exactly did you notice that was present in this particular report that was not reported?
So in this, it would be the item number is 1A1, and I can identify it because it has a 001. So if we go back to the first page and we saw that the clear top tube had 001 in front of it, that is, as I review the data, everything that I find that has 001 is tying it back to that specific item. So I'm not mixing up that with the other liver item or the homogenate. And so I was, there is presence of coca-ethylene in the windows. And if it's not there, then the window should be just a flat line. There should be no coloring of the little mountains or peaks in there. But the
Is this?
no, that's 285.
I apologize.
That's okay.
Let me make sure I have the right one. So, did you find in fact coca-ethylene in that report?
I found indication of. I will also say though that the you'll pull up so I can up or down. Sorry. Over to the right. That's the comforter.
Okay.
And so the ion ratios though on this are out, however. And what that is important to also note that even though it is in the window, the ion ratio is out. So it was below the reporting limit and it had another criteria that was also out for the reporting limits. But this was a very low sample and it was very, I don't know what all had happened to it prior to, so if we would have a full sample, I don't know if those ratios would have been able to be in because I would have had the full sample instead of having stuff removed because I don't know what the hospital took and I don't know what the hospital did to that tube prior to it being there.
Okay. And so did you in fact find a notation or an indication, if you will, of coca-ethylene?
Yes, it is present in both windows of the, there's a transition, you have a main transition and you have a second transition. And it looks at, for lack of better understanding, you have my water bottle as one transition and you have this cup as a second transition. You look at this ratio of the height between the two, and that's what it's talking about the ion ratio. That ratio needs to be consistent to call that drug. But just because it doesn't have the ion ratio, it should lend to further testing to look and see if it is actually present or not.
Would this be the correct?
No, that's 183.
Okay, sorry about that. So, but you can tell us that it was in fact an indication of coca-ethylene in this report.
There's indication in both windows, yes.
Now, you stated that the ion ratio was out, is that right?
Yes.
And so how can you then tell this jury that coca-ethylene, there was some indication of it?
The ion ratio being out doesn't mean that the instrument didn't see the analyte. The instrument saw the analyte and was able to generate a indication or a peaks in the window. If it wasn't there, it wouldn't have a peak in the window.
Okay, and did you in fact see a peak in the window in this particular testing?
I saw indications of yes.
Okay. What does that tell you in regard to whether or not coca-ethylene was present in the blood of Ms. Jade Benning?
As I said, it would just draw me to do further testing. With the ion ratios being out below the reportable limit, it would definitely cause me to run the test again, see if you can do microing, you can pull it down and reconstitute it and make it at a stronger concentration, and then rerun it and see if we would be able to obtain a value or not, to prove if it was there or not.
So if I draw your attention here at the bottom of page 3 of 4 of this report, do you see where it states coca-ethylene here?
Yes.
And is this a confirmation test?
Well, we're looking at the liver. You need to move up a little bit.
Sorry about that.
Okay, yeah.
Okay.
So this would be a confirmation because we can see that it's the liquid chromatography tandem mass spec. And that's where we're able to get the two different windows to see the transitions based on the instrumentation selected here. If this was a screen, it would have been an ELISA or an immunoassay type test.
So before they move to a confirmation test, what type of test do they perform first?
Typically, you would do a screening test, but in this case, I believe it went straight to confirmation. So they skipped the screening test and went straight to this test to look for the drugs.
Thank you. Are you familiar with coca-ethylene or the metabolite coca-ethylene?
Yes.
What is that?
It's a metabolite that is made only in the presence of ethyl alcohol and cocaine at the same time, and it's made in the liver.
And is there any other way, to your knowledge, that coca-ethylene can be formed in anyone's blood or urine or any matrix that you know of?
No, and that's what makes it unique about coca-ethylene, is the only way it is produced is with mixing cocaine and ethyl alcohol, or what we would call alcohol in our normal language, and it has to be at the liver at the same time.
And there was indication that here.
Yes.
Did you find that there were indications, and just so that we're clear, at what time was the blood sample taken for toxicology report number 231268889?
2/25/23, 22/31 military time, or 10:31 p.m.
And did you have an opportunity to review the medical records in this case?
I did.
And did you find in the medical records in this case an actual urine drug screen that matched the date and time in this toxicology report?
A urine drug screen?
Yes, well, urine was taken from Ms. Benning. Did you find that in the medical records?
Yes, I saw urine was taken. I don't have it in front of me. I don't know the time, but I know it was taken on 2/25.
Did you find that it was consistent with what you saw here?
This was a blood.
In terms of this report?
So this was a blood sample.
I'm sorry, not urine, blood, yes.
So I did see in the medical records that there was blood taken. There were several orders of blood being ordered at the 22/31 in the ER medical records.
Yes, that's my apologies for saying that. Now let's go now. You were talking earlier that I had showed you the comforter. Do you remember that?
Yes, ma'am.
And that would be toxicology report 231-29285. Do you remember that?
Yes, ma'am.
I want to show you now what would be considered the data from that report. Would that be consistent with that?
Yes, this is a summary page of the coca-ethylene.
And the comforter in this case, would that be the comforter that was recovered from Ms. Jade Benning's home?
According to the documentation provided in the literature packet, yes.
And did you learn that on that comforter that Ms. Benning had vomited on that comforter, according to what was told in the facts of this case?
Yes.
And as a result of that, did NMS perform testing on that vomit?
Yes.
And is this a result of the testing that was performed on that vomit?
It's one of them.
And did they find in that vomit coca-ethylene or an indication thereof?
So yes, if I can, just to help the jury to see what you're looking at besides just a bunch of numbers. Sorry, switch the other way. Sorry. Yes.
Okay.
If you look at line item number 43 and 44, and what I'm looking at to identify this is the 007 number. And if you would show the cover page so that the jury can see where that
Yes,
number comes from.
you can go ahead.
Okay, so they extracted at the same time controls. So the low control is labeled 003. The case blank, so that would have been based on
Congratulations,
documentation. It was
Tiffany.
taken from an area completely away from where the vomit stain was, but of the same material in which they were extracting for this case to look at the vomit, and that was listed as 004. And then you have a high control, and that's listed as 005. And then they have a lab blank. So they took another piece of fabric or something from a case unrelated completely to this case and extracted it in the same manner. And that was listed as 006. And then 007 is the case sample. So that would be where the vomit would be taken from the stain of where the vomit is to believed. And so that is how I then correlate looking at the data where we see the 007 1G1. The 1G1, all that is showing is the extraction vial that had been labeled so they can go back to their reports and such. And then the 1+99 is the 100 times dilution. And then the one below it, the 1+9, is the ×10 dilution from the original extracted liquid that they pulled off of a material. And then if you look under where it says nanograms per mil, where you see the 2.8, 2.6, we see that there's actually some values there. And if we scroll all the way to the far right, this one actually has the ion ratios in. And if we at the top, it'll say ion ratios out, yes means that they're out. And then if it says no, it means that they're in. So
you see that there?
yeah, so if we down a little bit, up. And then we want to look at the 1.9.
Let me scroll.
Yes, there we go. You can just see all the no's on the side.
Okay.
So
And you said the 1.9?
the 1+9, so vial item 43, go up a little bit. Up. So the 05 is showing you that high calibrator. So they ran a calibrator at the same time as they ran the case sample to make sure that their calibrator is still reporting and responding the way they intended it to respond when they did the original extraction at the very beginning. So that's just the checks and balance for them.
Okay. And so is the ion ratio that we talked about before, is that present in this particular test?
Yes.
Okay. And what does that tell you that is different than what the other test told you?
That this one would have been reported had it been above that LOQ or LOD. This is a reportable value.
And this was in fact found in the vomit of Ms. Benning on the evening of 2/25/23.
It was found on the comforter.
Thank you. Was there anything else of value that was found on the comforter from Ms. Benning?
That was found on the comforter?
In the vomit, yes.
No, I think that was it, that it was there, but it's below the reportable limit, and so it wasn't reported.
And what exactly would that have been that was there but was not above the reportable limit?
And that would the fentanyl as well. And so
Is this you're looking at the number here?
Yeah. So 007, so that indicates us that is the case sample. We're not looking at a blank, we're not looking at a QC. And the 1+1 is a dilution of some sort that they're doing. I'm not sure what the dilution is, other than because they had to extract it from a solid material, probably into a water with some steps that they did. And then if you see the two windows on the top where it says fentanyl quant, the two on the left is the deuterated internal standard. So that is something that was put there to know that the instrument is responding correctly and is doing what it's supposed to. The two on the right under fentanyl quant is the sample of the unknown. So if you look at the one that's below it, it's hard to read because it's blurry. It says norfentanyl quant, that second one, how it just has a squiggly line and there's no actual peak there, then that's not there. But if
you give us a minute to see if we can fix it so that it can.
Yes. But you just need to see that those peaks are there. That's what the indication is. If it's not there and it's not indicated, then you would have what you look like there at the norfentanyl. You have to have both transitions for it to say that it is an indication that there is something there.
Okay. And so did you find that there was an indication of fentanyl in the vomit of Ms. Benning?
Yes, and I believe the concentration was very low.
Now, speaking of concentration, as a result of the type of testing that was performed on the vomit, are you able to quantify that vomit?
No.
And why is that?
The method that was used was a detective method. So you can't have the validation that needs to go through to do any kind of method extraction and method development for the instrument. It's a two-part, but they kind of go into one. A validation is at least 16 experiments. It looks at precision, it looks at bias, it looks at extraction, recovery, and all of that has to go into how they are able to report at the end of the day based on the reliability and such of the sample. And so if you have a qualitative assay, it is just that. It's present or it's not. You cannot assert any kind of number to it. And in this particular case, you really can't because the curve failed. Meaning you can't take, a curve is created with known concentrations to make a linear line. I like to kind of help you guys have an idea. If you remember, have kiddos that have elementary school and you were given an X and Y and you had two of them you had to find and you had to count across on your X and up to the Y or either way to find it. Think of that line as the calibration curve, and then the unknown is that X or Y that you're trying to track over to it. So if that curve is not successful and does not pass, then anything on that cannot be reliable. And so then you switch it to qualitative, and qualitative is just there. Quantitative is a number. And so it's present or it's not. You cannot put any kind of faith into the numbers that are produced from that report.
And so are you telling the jury that when it comes to the vomit, there was on Ms. Benning's comforter, that there was in fact an indication of fentanyl, and there was in fact an indication of cocaethylene.
Quantitatively, yes.
Now, the blood that was taken, as we were discussing previously, in regards to the litigation report 231268889, I asked you whether or not there was a corresponding date and time of blood collection for Ms. Benning. Do you remember that?
Yes, ma'am.
And that was in fact at the hospital for 225 at 2231, is that correct?
Yes, ma'am.
Did you have an opportunity to look in the medical records to determine whether or not Ms. Benning had been given fentanyl at the hospital prior to that time?
There is notations in the medical records. It says that it was pulled and then it says it was wasted, and so I'm not clear if it was given or not.
And that's something for more of a medical professional to discuss, but
Yes.
I just wanted to know whether or not you had the opportunity to review that.
I did.
Let's now discuss whether or not, or tell me this, what does it take for you as a toxicologist that works in a laboratory to review records if you were to look over someone's work in order for you to sign your name to it? Can you tell this jury what all that would take?
Objection, Your Honor, to the relevance.
May I respond, Your Honor?
I'll overrule the judge. Go ahead.
So in my experience working in the laboratory, we've had people leave and had to review their work and whatnot. For myself to put my name on a report and take responsibility for that work, I looked specifically at the QCs. I looked at the calibration data or the qualitative data, whatever it is. But I looked at the entire case, and many times I would actually go to the instrument and I would look at the raw data. So there's printed computer data and then there's raw data. Raw data is what is done in the software. That's well above my knowledge as it comes off the instrument and it computes it into the computer. The reason I specifically would want to go look at that raw data is an analyst can manipulate that data and then it will print, and you don't know in many cases if that data was manipulated or not. So if I'm going to be putting my name on that paper, I want to make sure that that data is true as it is on the computer. I want to look and make sure that the entire batch had consistent results.
I knew something was going to come up.
When
Gross
you
data.
look at the lit packet
You got to
does
call
include
Megan in there.
the calibration and the controls, but we're only getting a snapshot of just this case. In many of these samples, there was hundreds of cases ran at the same time. So if you take a 35 millimeter film strip and you take out one picture, but what happened?
Real quick, we know, of course, your expert is going to prove your case, or should hopefully. So I take each expert's testimony with a grain of salt. I think where I like to see is the cross-examination. If in cross-examination you can get the expert to go ahead and agree with your expert, then that's successful. But if the only time you get the answers you want is with your expert, that's what raises a red flag for me. We know that it was an argument with the last expert. Anytime the defense asked them things and said, oh no, that was not the right date, but didn't fail to say that the right date was changed by the DA 10 days before trial. I am going to be very interested to see how this particular expert does on cross, because if this particular expert does the same thing and cannot hold up straight up answering questions on cross, then it's going to be a wash for the experts for me.
Before what happened after it, if I'm putting my name to sign up that case, I want to know that everything was before it. There was no problems with the instrument. There was no delays. There was no other issues, and correspondingly after it as well. And so it takes time to go through that data. Even doing this for 10 years, it still takes some time to review all of that.
And did you have an opportunity to look at the litigation packet as it relates to the litigation packet we were speaking of that ended in 889?
I did.
Do you remember how many pages of documents was that litigation packet?
I believe this one was around 1,900 pages.
1,912. Do you remember that specifically?
Yes.
And in your opinion, in order for an analyst to be able to review 1,912 pages of data, how long would you say that would take?
Just to review the lit packet and not look at the entire batch would take a significant amount of time.
Okay. What would be a significant amount of time?
To tell you, it took me almost an entire day just to go through just the lit packet myself and to look at everything and look at the controls, look at the responses, look and see if there's indications in the windows, and look at the entirety of just the lit packet. That's not looking at the entire batch.
And would you believe that you would be able to look at 1,912 pages in a fashion that you could sign off on it as having reviewed it in its entirety in less than 55 minutes?
Me personally, absolutely not.
Do you know of any situation in your experience as a laboratory toxicologist, with all that you know that it requires, any situation where that could be done based on your opinion?
It would be difficult to do a thorough review before putting a name on the bottom of it and taking true ownership of that data.
Now, let's say that there was another packet that you needed to review, and that packet was over 2,600 pages. Given the same example and having to review both of those packets in less than an hour, would you believe that that would be possible?
Not to review the entire litigation packet and to do a thorough review of it.
Can you tell this jury exactly how many people actually have to perform testing in order for a toxicology report, let's say for 231-26889, the one that's 1,912 pages, how many people perform tests in that litigation packet?
For NMS specifically, because every laboratory is different, NMS specifically, there was, I believe, 4 to 5 people who handled something in the preparatory of that sample. So from my understanding, I don't work at NMS, but from doing review and talking to colleagues that work there, it starts off with one person who receives the package, and then it goes to another person who does an aliquot. So it's a big science word. An aliquot is a sample of the whole. So if you think of a piece of pie and you take your slice of pie out, you've taken an aliquot of pie. And then they then put the rest of it aside. And I'm guessing so it's easier to maintain and move through. Doing 130 samples in one batch is significant, a number of tubes you would be having. And then it goes to another person who preps the sample. And then it goes to another person who does the extraction for the sample. And then someone puts it on the instrument. And then someone reviews it coming off the instrument. And then it goes to the review person after that. And then it appears with Dr. Methune to release the report to the customer at the end. So it goes through multiple hands along the way.
I want to show you an example of both of those packets that I just discussed with you about the review of those packets. Can you see these packets here, or do I need to move them over there?
I can see them.
Okay. And so this is the data that is compiled in 2 of those packets. In your professional opinion, Dr. Jagari, can you review adequately everything that you explained, all those individuals who had to run through this testing and perform some of the data that goes along in here? And I'd like to just show the jury and orient them to some of the data that you must review.
Objection, Your Honor, this witness cannot authenticate data, and I object.
I'm not asking her to authenticate it.
I'm asking that anything be shown to the jury that has not been.
Okay,
admitted
you're just
since
asking
then.
to show.
I'm just asking a question.
You've already asked that question about the volume, so.
And so, this is just an example of all the data that's compiled in those litigation packets, is it not?
It is.
And does a analyst who signs off on this packet to sponsor that all of this information is correct, would they have to review all of this paperwork and data?
In my opinion, yes, before they put their name on it.
Can you do that in 53 minutes, Dr. Jagera?
Not unless you're a speed reader.
Thank you. I'll pass the release.
Question from the state.
Yes, Judge, because of the circumstances, can I have just 5 minutes?
Okay. If you'll step down the hallway, ladies and gentlemen.
Of course, she needs those 5 minutes so she can get up there and she want to be able to ask that lady on the phone, help, please.
If you're wanting Joe Norman just to speak with Linda,
Yes, Your Honor.
is that gonna be the case? Is she gonna need to listen to Dr. Mario Bartolome, Dr. Kelly Larkin, and Dr. Lindsay?
I believe that Dr. Carney is our expert that would be for the other three. It's
Oh,
just
okay.
Dr. Mifflin with this person. If I could just have a few minutes to speak to her.
Okay, all right, we'll take a 5-minute break. I guess hang her up there and call her on her cell phone.
Court in a brief recess.
She did not look at any of the case blanks that would put in that run to assess if there was any carryover issues or any other instrumentation.
All right, we were a few minutes behind, but I did want to give me some popcorn and some Pepsi. So we are closer to being live.
Telling us the number you want.
Am I talking into the microphone? Okay.
We off by about a minute and 12 seconds.
Yeah.
Okay. Okay.
All right, now make it good. Say you done got the phone a friend. Got my popcorn. Oh, now you got to call it back and get it back on the phone.
Yes, I can.
All right, let the jury step back.
Ms. Collins, let's see those couple of lab paperwork that you showed her when she says one.
I gave you a copy of this.
Would they be exhibits?
No, they're already in part of the record. I gave it to Ms. Pendleton.
Yeah, but there was one for the hospital blood, I didn't get that.
Oh, now you're trying to find the page you didn't get.
That one was actually the hospital, urine, not the blood.
Okay.
I heard he had a tiny desk earlier. Go watch it. I just finished Fred Hammond's tiny desk yesterday.
No, I haven't seen
This is the, I didn't show you this.
So you asked her about something, but you don't have that paperwork?
I mean, put me back on mute. But she keeps trying it.
you needing something.
Keeps trying it.
Okay.
Sorry, now what's your name?
Dr. Gier.
Dr. Gier. Okay, Dr. Gier, do you actually do any lab assessments?
What do you mean by lab assessments?
You know, do you go to other labs and do you perform an assessment of the lab?
When I worked at the laboratory, I did the internal auditing of our own laboratory. So yes, I did do assessments. I don't do external assessments.
Okay, so you are not trained in assessing and reviewing another laboratory's standards and processes?
If you're asking if I am been through the ANAB assessor training, I have not.
You have not been through the ANAB assessor training.
I have not.
But you are here testifying about the processes of NMS labs.
I'm testifying to their data, yes.
Okay, but you are not trained as an ANAB lab assessor, correct?
Correct.
Okay, and did you know that Dr. Mifflin is trained as an ANAB lab assessor?
No, that's great.
So she actually goes to other labs outside of her own lab and she audits them for their standards and accreditation. And she has been trained in that. Did you know that?
No, I didn't.
Okay. You referenced that you reviewed the first hospital blood and you were talking about some seals. And your
That's great.
notes
I love
that
it.
Defense counsel provided just before you testified, your notes under the report from forensic medical 23126889, you list what samples were submitted, and it says blood, in parentheses, Jade, liver, in parentheses, Jade, liver, in parentheses, baby. These are your notes.
Can I see that? Because I don't have a copy of that.
Sure.
Ma'am, move on. At some point, she figured out it was the baby's liver tissue.
Okay.
You don't know
your
what time
question?
she wrote the notes.
Your outline of notes, you list blood, in parentheses, Jade, liver, in parentheses, Jade, liver, in parentheses, baby, correct?
Yes.
Okay, so those are your notes reviewing these laboratory results, correct?
Yes.
Thank you. So apparently you are not aware that Jade's liver tissue was not submitted for testing, correct?
No, when I made that you're referring to, that was my work product. That was just stuff as I was looking at it, and I didn't know if that was Jade's or if it was the baby's, because there's two listings for the liver. There's the homogenate and then there's the liver. So I didn't know what was what at the time when I made that list. I had since got clarification, and that is an older work product that I had. So that was not updated prior to my testimony for today.
You didn't update it when it was clear that it was only fetal tissue that was submitted. It was documented in multiple different places, but you didn't notice that. Going on to your comforter testimony, which again, you are not trained in any type of assessment for another lab, but would you at least agree with Dr. Mithun that reviewing data from your own lab is a different process than reviewing data from an outside lab? Would
Yes,
you
it
agree
can
with
be.
that? It doesn't take as much time because she is familiar with all of the NMS processes. Do you agree with her on that?
That could be true, yes.
Okay. And Ms. Hollins took all this paperwork and stacked it up. The litigation packet is in no way, shape, or form required or relevant to do a specific case review. Don't you agree?
No, it should be.
Now, you were doing a case review to assist the defense with litigation. Dr. Mithun was looking at testing of a very specific case. She was doing a case review. You don't agree that those are two completely different things?
I think both reviews should be equally the same, because as maybe I am reviewing for the defense, she's reviewing for the prosecution, and it should look at the entire batch and all of the quality controls and all of the standards and all of the paperwork to make sure that there is nothing that was missed within the other people's reviews.
Dr. Gear, you are very aware that what Dr. Mithun did was a separate forensic analysis. She wasn't doing it for the state. The state made a request that it be done. It is completely different than what you were doing for defense counsel.
We're both reviewing the litigation and reviewing the data to look at the accuracy, the reliability, and the dependability of that data.
Were you in the courtroom when Dr. Mithun testified?
I was.
Okay, and so her explanation for why she did not need to review the litigation packet, you think that's insufficient because you would do it?
Her testimony was she only looked at the case data and she looked at the summary pages. She did not look at the controls, she did not look at the calibration, and she did not look at any of the case blanks that would put in that run to assess if there was any carryover issues or any other instrumentation issues. She did look at a very specific part instead of looking at the completeness of the run.
So you must have missed the part where she testified that she had been reviewing the data in the casework for all of the reports since at least October of 2025.
I'm gonna object to argument if you're on.
Okay, she's asking, do you recall that?
I recall her testifying to that, yes.
And you also said that you were not sure what the dilution level is.
Which one are you referring to? There were several that had dilutions.
On the comforter,
Okay.
comforter samples, you're saying you don't know.
I don't know the factors in which they did the dilution. So when I worked in a laboratory, if we ran a dilution, we had to document, we took 5 grams to 15 mils of water to make that dilution, and we recorded that math. So anyone who was reviewing our documents could go back and know what factors and what dilutions we were doing and how we came to get to that dilution. All I have on this is a 1+1. I don't know the amount that it started with, and I don't know how much of the liquid solvent would have been added to it to allow for the dilution to take place.
Okay, well, that is what the dilution level is. If it's 1+1, if it's 1+9, it's 10. If it's 1+99, it's 100. And that is what is listed and documented in all of the NMS values.
I don't know the math.
You didn't understand how to interpret and do the math of 1+99.
No, ma'am, I understood.
Okay, she can ask her question. Go ahead, you were answering.
No, I understand that it
Are
was
you
not documented
like
on where they derived to get to the 1+99 or to the 1+1. I don't know where she started from to get to that. So in my laboratory, when we would do, in this case, like the liver, we would take 5 grams of the liver plus 15 mils of water to get a 4 times dilution. That math was not provided for the dilution, so I don't know where it originated from.
So you're saying you don't know that it was a 10 times dilution and a 100 times dilution, that you couldn't interpret that?
That's not what I'm saying.
I don't have anything else.
Just briefly.
Brief, okay.
I wanted to just clear something up real quickly. If you remember, I asked you originally, were you aware of who the liver belonged to? Do you remember that question?
Yes.
And what did you say?
Originally, I did not,
And why not?
because of the way it was written on the submission form and the report. It had the same medical examiner number. It was later on that I learned that it may have been maybe marked wrong. It was the liver of the fetus, not of the decedent, as it appears on the report.
I want to show you. As it is listed here, does it say who the liver belongs to here?
It does not. And in my previous experience working in a medical examiner office, if they come with the same labeled as number, it's from the same person, versus if it would have been the fetus in the laboratory I was in, it would have been given a daughter number or a separate number so that the testing could be separated.
And that is for litigation packet 231268889.
Yes, ma'am.
And did you see anywhere else where the liver was associated with the fetus of Miss Benning?
Only in the autopsy report.
And I apologize, my PowerPoint didn't work earlier, so I didn't have my paperwork. But you had asked me to give you this document so that you could assign the numbers
I can't believe
to
it stated
the
this thing.
diamond on the comforter. Do you remember that?
Yes, and it was to have the jury understand how I was able to look at the data and relate the data that was produced to the corresponding sample that was run at the same time. So-
Is this the data that you were speaking of?
Yes, so if you see where it says sample ID in the 003 and the next column labeled as flow control, and then it has the description of what that control or that item is, that's where I was using that report to look at the data to correspond the data to the appropriate item number.
Okay. And if you were to turn to the next page, because you were citing 007.
Yes, and you see where it's created from the fabric of the area with the visible stains, and it's labeled as the case sample.
Was there anywhere else on the comforter outside of the vomiters where fentanyl was found?
Yes, it was found in the case blank.
And would that be 004?
Yes, and again, the case blank is taken from the comforter, separate away from the stain of which they were testing for the case sample to make sure that the material was responding the same way.
And should fentanyl have any indication on the case blank? Or were they expecting in the test for fentanyl to show up on the case, if you know?
I would think no, because it's called a blank, which means it should be negative for any analyte in which you're looking for. It didn't say blank plus fentanyl, so.
Any other questions?
Just briefly.
Okay.
Again, doctor, you were here when Dr. Minton testified, correct?
Yes, ma'am.
And she testified about fentanyl being found in a very low number across the fabric. And she talked about the fact that that was kind of noise an issue and it did not mean anything. The level was so low. Do you recall that?
Actually, I think her testimony was that it was present and that it wasn't the noise because she saw both of the peaks in both windows and the ion ratio was in.
And she said there was absolutely none of it in the vomit, but it was something that showed up across the entirety of the fabric. Do you recall that?
I don't. I believe her testimony was that it was.
My question was, do you recall that? So you're saying you don't recall that that was her testimony?
Not that that was her testimony.
So she already testified about this, but you do agree that when you are looking at any of these levels, and you've talked about different levels without giving a ton of specific information, but it is a multi-point inspection. It is not just saying one value, one peak. You have to look at multiple variables that have to be present before it can be reported out. That's the entirety of the standardization and accreditation process.
Object to counsel testifying, is there a question?
I asked her if she agreed with that statement.
Go ahead. Do you understand the question?
No.
You don't understand that when you are looking at lab values or a peak, that it is a multi-point inspection. You are looking at multiple variables and you have to have multiple things present before you can report out that it is a substance that you are finding. That is part of the standards and the accreditation process. If you report it when you don't have multiple variables, that would not be standard process and your lab would not be accredited. Do you agree with that?
I agree that there are multiple facets that need to be met for a analyte to be reported, and that's what the validation process covers. But there are also it also has both transitions in both windows, and I believe her testimony said that it was present in the vomit.
Well, actually, the standards is part of what's in the litigation packet, which is part of the reason Dr. Minton doesn't need to review it, because she's familiar with the standards of NMS. So you didn't review the standards of NMS laboratories, what you're saying?
They weren't
Now,
provided in the
you ain't
litigation
said
packet.
nothing to her smart ass mouth all day.
Okay. Thank you. You can step down.
Thank you for your time.
Thank you, Rod.
I've been trying. I've been trying not to say what the hell has been at the front of my brain.
All right, ladies and gentlemen, the jury, we're going to break for lunch. Just remember what I said about not discussing the case, forming any opinion, looking things up, all of those admonitions. We'll be back here at 1:50. you said the other three expert or doctors that are listed here will be testifying, and then what about the other 1, 2, 3, 4, 5 people?
We will have the 3 doctors, Your Honor, and then, I'm sorry, we'll have 3 doctors. And then we need to read into the record the deposition of Alyssa Smith. And then, also we would have our forensic, telephone digital person.
Excuse me?
Our forensic digital person,
Who is that?
Eric Devlin.
And you provided a report from Lena Gill. We don't have anything from Eric Devlin.
As soon as he was going to testify to the report from Lena Gill, but.
From where?
Lena Gill, but she's not testifying, and so we will provide the report from Mr. Devlin.
You have the report from Alina Gill?
I have a report from Lena Gill. I
Okay.
do not have anything from Eric Devlin.
But they're gonna have a surrogate witness.
Number, potentially a judge, but
Okay, they're objecting to Mr. Devlin.
Like that, he was noticed as an expert.
in video surveillance is what we were told.
He's a digital forensic expert, and we provided his CV. With
You're
all his
wanting him to
qualifications on
testify about what?
The telephone, Ms. Bennett.
What
I'm
telephone?
sorry, Ms. Benning.
The
Ms.
text?
Bennett's telephone, yes.
Judge, I would ask for a jury out before they submit text messages to be introduced. The ones in the report.
Are you talking about the ones that have already been introduced?
No, these are others.
From when?
From the time period that we are allowed to be constrained.
About what?
So the state has put on evidence.
About what?
It will be about Ms. Benning dating other men. It will be about Ms. Benning's involvement with drugs. And it will be about Ms. Benning's involvement with drugs during her pregnancy.
Judge, the majority of the report is completely outside of January and February of 2023. They went all the way back to May of 2022 before she had ever even met
Okay.
Mr.
So
Taylor.
there's an objection about the relevancy, so we'll need to hear
We
from
will
Mr.
stay, will represent to the court that we will stay within the time period from when Ms. Benning met Mr. Taylor until February 25th.
The state has an objection to relevance, and I would ask for a jury out before she is allowed to call a witness,
Okay.
especially based
Have
on.
you got the text you're wanting to show Mr. Devlin?
Yes,
Have you given them to the state?
we're adding a few, so based on the state's, presentation of evidence and their case in chief, we are adding.
So they've got everything but the few you're adding.
Exactly.
Okay, and how do you define the few?
I'm not sure, I'll check and see where we are in a few
I
minutes.
mean, 2 or 50?
It will probably be more like 30 to 40, I'm sure, because they provided us with 30, and then when we got to trial, it was over 100.
Judge, I provided them updates. Mr. Brandon, I communicated, I sent him information.
Okay, you better get them printed out real quickly. So you have the 3 doctors and then Mr. Devlin, is that it?
And the deposition of Alyssa Smith.
And who is Alyssa Smith?
She was the EMT that worked at
Oh.
Vanderbilt when Ms. Benning arrived at the hospital. She
And
is
is
the one.
okay, I've got it. Is that not the video? Okay, you said read into the record.
I wasn't sure how the court did it, so it doesn't matter.
If you have a recording, would just play it on your, through a thumb drive.
And then, we also have Dr. Rubalai.
Judge, before you write, the other doctors, are there any notes?
I thought they provided those in the emails.
We only have Larkin.
Is that the only person that has notes?
So I did, Dr.
That's just a simple question. Thought you said you were gonna have all of the others provided.
I've been in court, so I don't know the update of where they are.
All the
So
people that keep running in and out the door, did they get them?
if you give me an opportunity to ask them, I will.
Okay, go ahead. I'm not gonna wait with this jury here on stuff you haven't provided. Just won't come in.
We're not offering anything into evidence.
But they're entitled to Jeep's material,
I'm giving it to you.
and that's it.
That's it. That's all I have. She hasn't sent me anything.
She who?
Dr. Lindsay.
Is she here?
She is, you know what? There is a article that she sent.
Has your staff asked her if she's got notes?
Yes, they did.
And she doesn't have
That's what she provided.
Judge, those are allegedly notes.
Okay. So what do you want me to do?
I'm likely to exclude her as a witness. These are not notes. There's a couple scribbles on a piece of paper.
Okay. Well,
These
you
are
can do your Perry Mason moment with her.
Thanks, Judge.
So they have everything that these individuals are gonna say that they notated. Is that accurate?
So I don't have their notes. They've given me what they have.
Has your staff gotten everything from these additional 3 people that would be considered notes and or reports?
Your Honor, as far as I know.
I'm not asking you, I'm asking the people that are here being paid to represent Mr. Taylor. Do they have it or not?
I explained to you that I gave them what they gave me. And I have to ask Ms. Lewis, because if I'm in questioning witnesses.
You were gonna ask Ms. Lewis.
Will you stop them from answering?
I'm not asking her, I'm asking you. Do they have everything that these 3 people have in terms of notes?
Yes, they do. Thank you.
So they do? Okay,
Yes, they do.
certainly. So if something else comes in, then other than what they've got, you got a problem.
Well, we have Devlin, of course.
Excuse me?
We have Devlin with his court, we have that. They don't have to make notes to
Get them
testify.
the text that you're adding, the few 30 that you've added, so we don't have to delay the jury trial anymore.
What's the let's recess?
I don't know what this judge's problem is. And I'm going to be honest, I don't feel. Did you say what time we were coming back?
If something else comes in, then other than what they've got, you got a problem. Okay, and Ms. Holland, you said the other back here is 150.
1:15. Okay. 150. Okay. All right, guys, we will be back then in about 42 minutes. Oh my God. I don't think he understands or may not care that his attitude towards the defense is making Miss DA think that it's okay to talk to the defense in that way. I tried to overlook or not address what I was thinking in my mind with all the, well, who told you that? Her. She said, her. You know exactly what her name is. Not only is it uber unprofessional when you can just simply say, Mrs. Hollins, and you've been doing it all day. You refuse. You started out, and I was thinking maybe it's a little hard to correctly pronounce her hyphenated name, even though I call bullshit, because if you wanted to pronounce it, you could. And so you were calling her Mrs. Hollins until she started pissing you off, and now she's she and her. as if she didn't pass the same bar that you did and she's not in there in the same capacity that you are. But to continuously do it and then have the judge cut her off at the knees on multiple, and there's some days where he's equally spicy, but the thing is, his spiciness, Mrs. Quinones Hollins does not take his spiciness and use it at the DA. However, the DA thinks it's okay to mirror the judge's spiciness and throw it back at the defense, mainly when she's not getting her way, which is coming off more like a temper tantrum than anything. And the reason why I call it a temper tantrum is because you just had it with the doctor that was on the stand. You just had an attitude with the doctor that was on the stand simply because she was saying something other than what you wanted her to say, without at least at bare fucking minimum understanding that this ain't my witness and I ain't pay her. What did you think she was going to get up there and say? Well, that's the problem. You can't respect the thing that you can't respect someone that you won't even give a name. You don't respect her. And calling a thing, those are nothing but microaggressions. The only problem is the judge finds it hard to be equally as spicy, because when she kept saying romantically tied, she was dating other men. Could you just lose the adjectives and just ask a question? Quit trying to be fancy and just ask the question. But when the state says, oh, right, well, she's accredited, she is qualified as an assessor, you're not. So since you're not one thing about all the commentary, not one thing about the adjectives, not one thing about being fancy. When you absolutely knew that that was something. See, we always try. The hardest time to do something is the first time. And if you've seen somebody else get in trouble for it over and over and over again, you kind of know not to do it because he might say something to you. So the first time you got your little commentary off and he didn't say anything to you, you doubled up on it and did it again. Once is an anomaly and twice is a trend, and now you're trending with all this commentary. Problem is, your cross-examination did not contain anything that reverted her back to facts, but the fact that, hey, she might not take all day to re-review something because, one, she's a trained assessor of other labs. So that, on top of the fact that she was re-reviewing her own lab, means she could have been able to do it real fast because she was more familiar. Okay. Okay. But what do you have to say about these samples? What do you have to say about the trace amounts of fentanyl? Because the DA ended her direct and redirect, or the testimony period of her expert, by saying what was traceable, what were the amounts that were reportable, what was reported in the vomit and in the blood. Just sugar and its byproducts or metabolites. She did acknowledge that the cocaethylene was there in trace. She did acknowledge that the fentanyl was there in trace. But what you had her end on was that the only thing that the machines were going to report out on unequivocally was the sugar, its byproducts, and its metabolites. Doesn't mean that those things weren't there. Doesn't mean we should ignore them just because you say they weren't. And honestly, you probably should have focused on them. Yes, a trace amount. Yeah, it's not that much. But how much fentanyl does it take to kill a person? You probably should have focused on them, especially since her symptoms. Why didn't you focus on showing that the symptoms that Jade had come from the coke? Because your doctor, your expert DA, said that the symptoms explained symptoms that she was having, and then explained that is that of depressants like fentanyl. Nothing was wrong with her heart. no heart attack, nothing you normally get from the adult sugar. I think that that's going to, we'll see. I mean, it doesn't mean anything in terms of guilt or innocence, but I do think that it's very noticeable at this point who is acting like a child. I hate to say that because these are two grown people who have busted their asses for their education, has had probably days of crying, wet pillows, sleepless nights trying to pass exams, waited on their results from the bar, became attorneys, got their first jobs, tried their first case. These women have been through hell, fire, and damnation to become these barred attorneys. And to turn around and act like this with that degree in your back pocket is crazy. It's crazy to me. There's no way I would let that piece of paper I worked so hard for start looking more like Charmin toilet tissue. Get your attitude together. Maybe she need to eat or something. But it's very disheartening to see. Very disheartening to see. And I'm glad somebody is maintaining their professionalism. All right, guys, we'll be back in about 30 minutes. Integrity goes a long way. It does. And being rude, having an attitude, snippy comments, they don't change the facts. Just change the way somebody views you, but it won't change the facts of the case. Prove your case. You wouldn't have to have an attitude. All right, guys. See y'all in about 30 minutes.